May I please, Your Lordship? Your Lordship, this is an application for suspension of sentence, my Lord, and my Lord, no date is showing, my Lord, so may kindly give me some
It's an application for
suspension of sentence.
listed. Next.
Yes.
Some matrimonial matter. Okay, next, call the next.
Please, my lords. This is an SLP. I am for the respondent number 2, the person who's been awarded the tender. There's a stay on the works, although the tender has been upheld. The award in my favor.
We granted stay.
Yes, my lords.
We'll list it.
Work is pending for over two years, my lords.
No, we'll list it.
Please, deeply obliged, my lords.
This side of the vacation.
Deeply obliged.
My lords, may I refer to your, may I make a mention? I would refer to your order of 4th of May, where this SLP along with IA was directed to be listed today. It's not been listed today and we were seeking urgent relief, my lords. It's the Basketball Association matter, and we apprehend that the state association will hold tournaments and we won't get
I
an...
told you that there's no interim orders passed for that.
But my lords, the matter,
Please said it.
if the matter may be listed next week because there's no tentative date.
We'll see.
My lords, I seek
Correct.
your permission to mention an item listed before your lordships in the special bench today, my lords.
What do you want?
There's a matter listed in the special bench before your lordships as item 301 before your lordships and honorable
So what do you want?
My lords, there's some personal difficulty with
We'll
it.
see, let the bench,
Your
we'll
Lord-
mention it there.
Your Lordship, may I kindly mention this Damodar Valley Corporation matters of electricity against consumers in West Bengal. Lordship, on last date, the board was discharged and just the date was given to Mr. Sri Venkatesh. But unfortunately, the interim order has not been continued in the order itself. And
Same order, interim order to continue. Whatever is the order is there.
but my lords, the order does not record it, and the previous order recorded it. Yeah,
Then
that's why.
okay, unless it's vacated, it continues.
I'm grateful.
In item 1, I appear for respondent state. I seek 1 week time to file my counter.
Alright. We'll give him a week's time. Next.
Grateful, Lordship.
My lords, we're led by learned ASG seeking for a short passover.
Pass on.
Obliged.
The my lordship letter of intent has been issued to me, and at page number 121 is the clause, my lord, where I can offer the alternative land as well. The person who has filed the writ petition has filed after 2 years of the issuance of the LOI.
But you have not been given the contract, right? You are
No,
not been running it.
I have been given.
Till date, you have not been running it.
No, the
Why?
LOI.
Why? You
The
are,
LOI was issued to me at the first instance, and after that I said that
it was initially allotted to you.
Yes.
Change the plot.
yes, my lord, because it is
But have you
permissible.
established at all?
Because it is permissible.
No, you have not.
Please see page number 121, my lord, the rules, the guideline which says that the alternative plot I can offer if there is any problem.
To change.
The first LOI was issued to me.
Remaining this thing candidate.
After that, there was an issue with respect to the partition of the
What
land.
happens to note 3 and note 4? It provides that you should, the IOCL should choose amongst the remaining candidates if you have withdrawn the offer.
No,
Can't
but I
be
have not
allowed.
withdrawn the offer. I have not withdrawn the offer. I have only offered the
Amounts to
alternative.
withdrawing.
No, my lord, page number 121. Please see page number 121.
Unless a clause allows you to do that.
Yes, yes, like the very clause 121, my lordship. Please see clause 2.3. At
Yes.
page number 121. There may be cases where through the site offered by the applicant was found to be technically and commercially suitable, but NOC not being granted by the NHAI district authority due to unforeseen circumstances for which dealers select
Why
cannot be
NOC
held
provisional
responsible.
LOI is also given to you?
Yes, original LOI was
After that, you can't change. In case
After that, I
LOI
can
is
change.
Is not
page number 121, clause 2.3.
120?
Precisely. Page number 121,
clause.
clause 2.3.
Yes, tell us.
Yes, my lord. So, like the very clause says that in case the NOC is delayed of some reason, there may be cases where through the site offered by the applicant was found to be technically and commercially suitable, but the NOC not been granted by the NHI. Precisely is my case. Due to unforeseen circumstances for which dealer select cannot be held responsible. in such cases, the LOI holder may be allowed 6 months of time by the corporation to make available the alternate land in the advertisement. And it is within the same location.
NOC not being granted by NHAI.
So like in my case, NOC was the issue.
What NOC not, you are saying that no NOC has given to you?
Yes, ma'am. Please see at the page number of the
NOC not
Malaship.
being granted by NHAI district. NOC, for
NOC
your
was
case,
awaited.
provisional LOI is also given.
Yes, provisional LOI was given to me, but the NOC from the authority was awaited. And therefore, I offered alternate
Which
land.
authority, you know?
It is the NHI. And please see, my lord, as far as the NOC is concerned,
Provisional LOI shall be issued subject to clarification.
as far as the NOC is concerned, yes.
इसका तो नहीं आया लगता है NOC. But after that,
My
where have you
application
argued?
form at
Where
page.
is this? Where is this? You say that,
Yes, my lord.
and there's, what is the stand of,
Yes. So,
show us that, what is
on
the
the
stand?
stand of the
Where
my
have you
appli-
argued this? Where have you said this?
yes, my lord.
In the
Please see annexure
impugned order,
P.
show us, Kaustubh. Show us,
Impugned order.
show us from the impugned order that your NOC has not come. And how did the High Court deal with it?
Okay.
Nothing like that.
Yes, my lord. At
Keep
at
para-
page number 6.
Page
At
10.
page number 6, para number
10.
9. From the record, it is evident that the land initially offered by the appellant was evaluated by the committee and was found to be non-suitable on account of non-compliance with the NHI norms.
As found to be non-suitable on account of non-compliance.
After that, like the last
NHAI
four lines,
norms.
the appellant was granted
That's a
time to
different
apply.
point altogether.
The appellant, I will also show this on the form as well, my lord.
This is completely different, Kaustubh.
My lord, may please see my application form.
About alternative land. Reliance placed by the respondent,
If-
note 3 clause 3 is misconceived. Okay, can only where the can.
Right. Which is-
Okay, Kaustubh, thank you.
If,
Dismiss
my lord,
this.
may please see the form.
right,
my
you
lord.
have seen it
In
now.
fact, the very form says that the NOC is the
It is
issue, my lord.
different. Leave it.
I mean, my lord, in fact, the second LOI was also granted to me. It is not the case
Not-
that the land was not my lord, and it is not the case that,
See,
that I'm not.
there is no legally enforceable right. All you can claim is that you should be
Considered.
treated in a fair manner. It's nobody's case that this action is arbitrary.
So-
They have taken action the High Court has said in accordance with note 4 and 5. From the remaining available candidates, they should select a dealer.
It is
no
not the
legally
case where
enforceable
authority has rejected my application, no. It is the case where a writ petition filed a petition stating that I am not eligible
All right.
for the
All
particular
right,
license.
heard you. Okay. Thank you.
Deeply
Dismissed.
obliged.
Go.
No, I am tendering an apology that the impugned order has been left out to file, Your Lordship. It is my mistake. Impugned order has been left out. I am seeking 1 week time to file that, Your Lordship. I am extremely sorry.
Okay, give it in. What is left? That's right. I don't know what.
23rd order is not there.
There is one more order.
My Lord, one order is there, which I have seek on the prayer clause. That has been left out, Your Lordship.
Item 4, Bal Bharati thing.
Yes, Your Lordship.
There are,
What is there? Why are you hounding?
there are three
What reason?
orders.
What reason are you fighting this case?
My Lord,
They have found, the PCB has found that everything is right.
my Lord,
And UP grounds also.
yes.
Water
If-
department.
just I can supply the
something
hard
other than-
copy of the order.
Who are you appearing for? I mean, this seems to be
Lord.
a very doubtful case.
My Lord, it is not a
This
doubt.
PILs we are.
If my Lord will see just for a moment, the page 64 for a moment, my Lord.
This way of seeking adjournments also causes doubt, huh?
They
What
have
bona
not
fides?
completed any aspect in spite.
All right, Pollution Control Board has looked into it. They brought.
My Lord, pollution.
PIL can't be to the extent of a personal litigation.
No, I
Now
am,
you are a third party. Don't overdo it.
my Lord,
Dismiss. Next.
my Lord, just I want to file that.
Five, not necessary. Five,
My Lord, kindly bear with me for a moment, my Lord.
not necessary. Sir.
Whether we can allow the institutions to do illegal acts apart from all the laws, Your Lordship.
All right.
They have not paid the cost. They have not paid.
Called
installed
for a report.
They have not installed chimney. They have installed illegal DG, Your
ये
Lordship.
personal interest हो गया. Huh?
There are two.
And still they have not complied with that.
All right. Thank you. Dismiss. Next. Item 5.
Obliged.
Item 5, I've got a
5.3 minutes.
I'll come to that.
Wait a minute, she's saying something.
I've got a chart prepared of all the matters. All these matters are covered. I have made the chart where there are a batch has to be with the INC ISAC, the other has to be with AK Thapa.
Correct.
Two matters, 5.3, which my learned friend is saying, that's correct, because he's the petitioner and we are the respondents. There, my lords, we need to file a detailed counter affidavit.
5.3.
3. Let it not be tagged with any of the
We'll
batches.
separate it.
Yes.
Separate it. Then,
One more matter, my lords. 5.12.
yes.
That, my lords, is a separate category altogether.
What we will do is
Notice and
that
will be
which
listed.
are those matters which you are saying covered.
I've given the chart.
He has given the chart. Okay?
Yes.
The
I appear in 5.12 on advance notice, Your Lordship.
wait a minute. All these matters which you have given the list will be disposed of as per our judgment.
No, not disposed of, my lords. To be tagged.
Tagged on with Nana matter.
Yes. One is Nana, one is invalid pension that I have
So
mentioned.
this will go with Nana.
One with Nana and the next
Judgment
batch,
two letters. Okay.
invalid. Yes.
देख ले confuse मत करना.
Courtmaster, the last page has the second batch. ऊपर line लिखी हुई.
उसी batch में respect.
5.1 is covered, no? And
Yeah.
5.1.
My lords, 5.
Girish
No, my lords. No, my lords. DP Nana matter, my lords.
Sometimes overlap also happens.
Yes.
All right, we will examine. You understood? No doubt? No. Those which have to be disposed of, there is no need for notice.
There is no matter which.
Those
is
matters are not.
disposed of.
Okay, notice one.
Only
Are
tag.
these all fresh matters?
Yes, all are fresh.
Then we will issue notice and then tag.
Yes, yes.
Issue and post along with the batch. And 5.3 and 5.12 list on some other day.
Notice, my lords, that's my learned friend's matter.
Yeah, we issue notice.
5.12, where my learned friend appears on advance notice, my lords, that's also a separate
We'll issue notice,
designation.
take notice.
Lordship.
We'll list on some other day.
Well, we also have to, my lords, pressing for stay in that 5.12.
Oh, did you have a stay there?
My lords, my lords,
What's the
order
direction
is
there?
against us.
5.12, what's the
The
direction?
direction is that we give the disability element as well as the service element. We are giving the disability element, but so far as the service element is concerned, well, the person has actually resigned from service and he has not completed the 20 years of pensionable service.
Issue notice, pending disposal of special litigation, there shall be a stay only as regards service element till
Element.
the next date of hearing. Only till the next date of hearing, we will hear you and take a decision.
Okay, grateful, Your Lord.
I'm grateful. Delay, my lords, in all the matters. In all
much
the
is that?
matters, there are.
How much is that?
504, but it's a plus
77
days delay may not condone because it's a continuing round. Election is a continuing round. But
Notice.
Lordship, may I make just one submission? In 5.12, the AFT, the first court of instance, AFT had only granted us the disability element. We had not challenged for service.
That's why we are not staying that.
Grateful.
We
But
have not
they have-
stayed that.
Yes.
they have not issued the PPO for disability element as well. That is the.
That you enforce.
Do that, my lords, since there's no stay on disability element, we'll do that.
Okay. The petitioners will implement the judgment as regards the disability element of the direction.
Grateful, my lords.
Plus, there's a delay in all the matters.
We'll issue notice on all this.
Grateful, man.
Grateful. Grateful, Lordship.
My lordship, I am seeking a passover in this matter.
You have to go to the High Court. Universal Sampo.
My arguing counsel is in another court.
7.
Yes,
Item 7.
please, Your Lordship. My lord, both the occasion, my lord, I did not get nobody got a hearing with regard to the clauses in question. 5.2.8 clause, neither on this round,
Annual turnover of 4.5.
5 crores, my lord, please. My lord,
You may-
and also see, Your Lordship, this impugned order in which
Similar challenges. What happens to that winner farmer?
winner farmer. My lord, winner farmer, that matter, Your Lordships have heard a matter, that's a different matter. That is not concerning this. This particular tender, there is a
There
winner
is
farmer.
not Similar tender was upheld in winner farmer.
My lord, winner pharma is dismissed as withdrawn,
Then-
both of them.
Then,
Your Lordships have not gone into the clauses.
all right.
My lord, please have a look at the, my lord, even the office report. My lord, I am carrying the copies, both the matters, they have
There's one
dismissed.
more thing. This is the tender of December 24.
My lord,
We
may
are
I,
in 26.
may,
So what happened in the meanwhile?
BOQ issued,
Then-
financial bids have opened, no LOI issued till date. my lord, the difficulty is that, my lord, utterly illegal and arbitrary tender is being floated. My lord, 4.5 crores in the last 3 financial years, whereas admittedly out of the 5 financial years, 3 financial years, Odisha state government did not even go for a tender. This is, and at one point they are saying that there will be no item wise, but when they are receiving the tender, it is item wise, the BOQ.
Shows that order, winner farmers order.
Yes, yes, madam, yes. Madam, kindly, Appendix 3, my lord. Page 122, my lord.
Tender matters, it's a very, very difficult situation.
My lord, may kindly see winner farmer,
What we can understand, but.
what the High Court has done here. Page, my lord, running page number 122, Appendix 3, my lord, of my SLP volume 1.
Huh? Oh, yeah, you can't interpret.
वो वाला विनर फार्मा प्रिंट आउट देना जो सुप्रीम कोर्ट का है, जो उस पर है.
Largest tenders have gone ahead.
My lord, they have only gone on cellular operator and Jagdish Mandal. Jagdish Mandal is extracted, my lord, at page number 129, twin test extracted, and look what the High Court is saying at para number 9. In the light of the, there is no application vis-a-vis the twin test to my tender. My lord, please, my lord, please bear with me for a moment. Please come to para 9 at page number 132, my lord.
You are there in view of the word judicial pronouncement.
Yes,
What is of the.
absolutely. It's a judicial review. Judicial review, they have taken a decision without getting into the clauses, my lord. The clauses is yet to be tested by any judicial forum.
It is tested by division bench.
My lord,
In earlier round, it has been tested by the division bench.
my lord, not
That
before.
Same clauses.
Same tender.
May I hand over, my lord? May I hand over the order? This both are dismissed as
We are
withdrawn.
not interfering.
My lord, please, my lord.
Item is.
It's a more than 100 crore scam, my lord. Please, year after year, this is happening. And I'm not a PIL petitioner. I'm a player myself. I am not hiding behind any public interest litigation, my lord. No NGO. I'm a player myself. My lord, only 3 bidders participated. Mother, son, 2 persons are getting consistently.
Is your voice low? You don't need to raise your voice.
Awarded to the same parties for the last 3 years, my lord. And my lord, 3 parties participated. One Haryana fellow who participated, he was ousted on technical ground. Again, those 2 parties have gone. My lord, I have print out to show that a medicine which is costing in the retail market 100 rupees, they have quoted 350 rupees. Now it's a 147.
See, we'll tell you one thing, 2 basic things. For argument. When they prescribe for a standard pharma company, they are entitled to prescribe.
Yes.
What should be the annual turnover.
Yes.
And it is not for the participants to say it should be higher, it should be lower, my capacity is lower, so I can't bid. But this is not a private entity, it's a public entity. After consultation and formulating the tender, they prescribe a tender condition which applies across the board to everybody. If it were a discrimination, in the sense that somebody lower than you is accepted, yes, we will entertain. But a standard which is fixed, applicable to everybody, and people have participated in that, BOQs are also given. The question of in a tender matter entertaining wouldn't arise.
It's
Please
very,
understand.
very.
Thank you.
The state of affair is very.
Maybe, but then in a tender matter,
My lord, please appreciate, my lord.
It can't be that.
Basis also. Absolutely.
All right.
Allow me, I'll demonstrate, my lord.
Not necessary. Thank you.
And then I may be allowed to withdraw, my lord. Then I'll go back and file a review petition, my lord. I may be allowed.
Dismissed as withdrawn.
My lord. Oblige.
Next. Subrata Bhattacharya.
Please, my lords, this is an Article 32, my lords. It arises from the PACL matter, which my lords Justice Narasimha has been presiding over. However, my lords, in this case, we have limited to the fact that SEBI, by the abuse of power, has left.
Withdraw your IA.
Please, my lords.
Why did you withdraw that IA?
My lords, I have
Already
filed 2
noted
IAs,
that
my lords.
batch, you come out of that batch and then the amicus is also standing there.
My lord. My
So
lord,
you withdrew from that
My-
and then you are filing a 32 petition against the
My
same
lords,
thing?
there were 2 IAs, my lords, I had filed. My lords is referring to the IA against.
You can't walk out of the batch and then,
My lords, I was directed to the LODA committee.
that's right.
Yes, my lord. So, my lords, before the LODA committee also, I have always cooperated. In this court, I had moved an IA saying that please take the flats before the LODA committee.
Then if your property is actually
Yes, my lords.
mortgage is attached, then our orders will follow. So
My lord,
many of persons are identical like you, we have sent it back to the SAT.
I bow down to that, my lords. My lords, what I'm aggrieved by today is that my PAN cards are blocked, my all my accounts have been frozen, and not just of the partners.
When was that done?
My lords, 22. My lords, may I?
When was that done?
22, my lords. My lords, there are 3 orders.
2022.
Yes, my lord. Since
You are coming now in 2020.
pillar to post, my lord, for unblocking of my PAN cards, I have submitted it before SEBI also, my lord.
Everybody in that batch was standing exactly in the same position as you. You are not different in any way. Everyone's properties are attached.
My lords,
And all those cases where they are attached, bank accounts are attached, PAN cards are not.
yes, my lord.
We have referred them to Lodha committee. After Lodha committee, they have come back.
Yes, my lord.
They were wanting to they were asking us to pass orders cancelling your right to property. We said no, they should be given one more opportunity. We directed them to create tribunals. We have sent all of them there.
My lords, yes, my lords. I have also got that order, my lords.
Somebody asked file 32
May I-
petition out of a night.
My lords.
Dismissed.
My lords,
Don't, this is abuse of the process. We're going to dismiss it with cause.
would my lords,
You know everything is happening there. You walk out of that and file a 32 petition.
my lords will say, my lords, by 16th April, my lords had just passed an order in 16th April. I had moved an IA there also. My lords have sent me to the recovery officer.
That also you went.
My lords, right now, 16th April, my lords have
Then
passed an
why are
order.
you filing a 32?
My lords, that was, I have not asked for unblocking of PAN cards in that and refreezing of bank accounts. I have not asked in that. There is no parallel prayer that I have asked.
It can't happen simultaneously till that is you
My lords,
get clear of that.
my lords, for 4 years, my PAN cards are not just mine, my lords. The petitioner, the partnership company, the 4 partners, and all the relatives.
Okay, all right, we'll dismiss it with cause. Now we are saying that it is actually abuse. Anyway, leave it at that. Dismissed. 9.
My lords. Would my lords then
Withdraw and avail your remedy. Dismissed as withdrawn.
Millard,
Go back to the tribunal if you need it.
Millard, the question is
Number
already
9.
decided by this honorable court.
Sorry, mister?
The question is already decided whether an application under 11(6) of the Arbitration Act, Millard, can be decided by the same court. This question has been decided in para 92.
Limitation is also kept open.
Para 92 Arif Azim's case, Millard. The court specifically says that under 11(6), the court can decide on the question of limitation. And in this case, Millard,
They have kept it open also, no? They have also kept it open, saying that despite all that, it can be raised. While we are not inclined to interfere with the order passed by the High Court, we, in view of the fact that the High Court has kept even the question of law and fact relating to
Millard,
limitation
that is the grievance.
open for the tribunal, for the arbitral tribunal to be considered, especially petition is disposed of. Accordingly. Next. Not before. Not before, man.
My lords.
No, single. Single judge.
My lords, that page
We
number.
could have granted you relief, but what to do? Yeah, we understand. It's sad that the appeal is not heard. Is it okay, brother? We'll say that. Well, don't say that. Don't say. While we are not inclined to entertain the petition, I said, Bobby, you have not even asked for. Okay. Delay.
1,000 odd days.
Post before another bench. You will get it. You will get it. You will get an order.
Please, your lordships.
लिखते ना, give the reason why, not before a bench. In view of the urgency, a request is made for an early hearing. Full stop. The registry may seek instructions for early listing of the case. That's
But I have a preliminary objection. The tenure of the village panchayat is over now.
this one.
Yes.
Lordships, in that case,
Tenure is all over now.
tenure is over.
Today
In
we
that
bailed
case,
you out as much as we could.
So my prayer today is
Despite, but single judge also is passed an order.
Yes, ma'am. So
But
178.
sometime, Navre, we have to take.
I know, but
this
my lord,
we don't talk to you in every
No.
case about the facts of the case.
I'm not on
You
facts
are an
of the
officer
case.
of the court.
Yes, yes, I'm
So
not
we are
on facts of the
generally
case. I know what
sharing
your
our
lordships are
opinion with
suggesting.
you.
In fact,
Can't be done. You should not do
your
that.
lordships have observed on the last occasion. My lord, I also agree. My lord, till the time this provision remains, these kinds of provisions remain, my lord, people are bound to have a tendency, my lord, to take advantage of that. My lord, this
No, no,
statute,
it's attitude. It's the bureaucracy
yes, my lord, what
on
will we
asking,
deal with? What will we deal with?
on asking. Somebody says that he is walking on the left side of the road. So panchayat dismissed.
Disqualified.
What is this?
Lordships, may I say something?
Lords, there are certain provisions which are really
I think
necessary.
we should disable the executive from doing it.
Elected
It
representatives.
should only be through a motion of no confidence or by majority to take
Even on
action.
that,
after
Lord, there is a lot of politics. Even on that.
Politics will be inevitable. Politics is inevitable. Let politics play. Politics is it's a pejorative word. It's a representative democracy. Let it work. But bureaucracy can't interfere and remove panchayats and everybody just on asking of a rival candidate.
Lordships, may I
In
say
view of
something?
the fact that
Lordships, I would like to say
now what happens? Term is over, right?
yes, term is over. Page number 178 is important.
What's
When
that?
the writ petition was pending, in fact, it was
Anyway,
finally
you
approved.
continue till the term is over.
Yes, my lords, but my apprehension is different today. Page number 178, collector or Jilla Parishad passes an order that I will be continued as administrator, that is petitioner number 1, and petitioner number 2 will continue as a member. That order may be seen.
Continue means
Plus, please see page 178.
11. 1.
178, annexure P11. So this is as per High Court order, government resolutions
178.
178.
What is the date of that?
Date is
23rd February 26.
23rd February 2026. Impugned order is of 30th March.
So what is this?
Just see, my lords, I will just show. As per the second
Who
proviso,
passes this order?
this has been passed by
The Zilla
Jilla
Parishad.
Parishad of Solapur, and that is on the directions of the High Court.
No.
So what is it that
There was the order passed by the High Court. If we see,
furthermore, it is ordered that the establishment of an administrative committee consists of an executive Sarpanch, deputy Sarpanch.
page number 1,
No, are you saying that after our order?
after my lord's order before this court, and the writ petition was finally argued, the state government on the orders of the High Court, if you see point 4, that is interim order on page number 179. Interim order dated 9/2/2026 passed by the Honorable High Court, Nagpur bench under writ petition number 1250/2026. Pursuant to this order, all the Jilla Parishads have passed a notification where Sarpanches will continue as administrator, and there will be administrative committee of deputy Sarpanch and member, that is petitioner number 2. So today I have been ousted from that despite this order.
Why?
Because I have been
Because of single
disqualified.
judge's order.
So I need to be continued for 6 months as per
Because
this
single
order.
judge's order. Because of the single judge's order.
Single judge's order
Because
comes
single judge
later.
also ultimately, has he referred to our judgment, our order?
Yes, my lord.
He has only referred, but then it has not been.
But he has gone on to the merits of the matter.
Yes, my lord. And that is after the disqualification, after the term ends. So in
Anyway,
fact,
after our order, what
No, I
happened?
need
You were reinstated.
as per my lord's order, I was reinstated.
Then ठीक है.
18th,
Our order is complied with.
but then this needs to be. I need this protection.
When is the
explicit
term over?
protection. 20. This order shows 22nd February.
That you have a separate.
22nd
That
of
you have a separate. We'll keep it open. You challenge 22nd of
February.
Lordships, I don't need to challenge it.
2026, is it?
I need to be protected by view of this order. In view of this, my lords may read this order.
Lord, if he can't satisfy on merits, two authorities and the High Court will not have.
We leave it at that. In
concurrent-
view of the fact that the term of the Jilla Parishad, what is it?
No, village panchayat.
Village panchayats is the term has come to an end by 22nd of February 2026.
My lords may refer to this as well
We-
because
We
I am
no
protected by this order. When
reason to
still I was not
interfere
disqualified
with the order.
after
passed.
order was reserved.
Stays, my lord.
Leave it at that. SLP.
Grateful, my lords.
You avail your remedy.
So my lords may record that.
Okay, the petitioner is at liberty to avail against what orders? We'll just keep it
So
open.
that is what I can challenge anything.
That's why we will not say
need
anything.
Declare,
You avail your
I need direction for this that I can continue as administrator. My lords may read this annexure P11.
It's okay, now the term is over. You
For 6 months, I am
for your
entitled
term.
for this.
Please, my lord.
I call the next.
Grateful, my lords.
Malad, this is a modification application for the order, Malad, which has been passed on 13 January 2026. Why have with a liberty to approach DRT, Malad? What happened into this particular matter was
You
that
can file a review. What is this kind of an IS disposed of matters for clarification?
no, Malad, the reason is that they will take away my property. What happened into this matter, Malad? I'll tell you, Malad.
You want an advance ruling? Go and ask. If they say no, we can think of it.
Malad, they are not
Don't take
allowing.
advance
Malad,
rulings
the
for that.
registry is not allowing, Malad.
Okay.
That is the difficulty. And Malad, my
Hard
25 lakh rupees plus the interest amount is stuck there, Malad. So what happened into this particular matter,
No
Malad?
clarification. No clarification of our order. Next.
Malad, what happened into
That
Malad?
must be proper.
The Honorable High Court has dismissed it in a not looking into the proper merits of the matter, Malad.
Next.
Obliged, Malad.
13. Similar matters.
Yes, Your
Same order.
Lordship, yes. Kindly circulate it. Your Lordship, I dispose of the special limitation with liberty to file the writ.
Same order.
Deeply.
This is a matter, Malus, where the award itself had provided the venue and seat. It was declared so, Malus, and the Balco judgment had already come. In spite of that, Malus, they chose a wrong forum and continued to litigate till the time your lordships
See, the
interfered.
clarity came after our judgment.
Malus, no, it relies on Balco. If lordship would just have 2 paras of that judgment, Malus, because it relies on Balco, Malus, and Balco was 2012.
Arbitration as it is a very limited remedy under 34.
Yes, Malus,
So we have held that on technicalities, you can't deny 34. They went to a wrong forum and finally, first appellate court, there was a difference of opinion.
yes, Malus, there was.
The
First
High
appellate court
then
stated it in
therefore
spite.
there's no certainty in the courts also. Till the Supreme Court finally said it.
Yes, Malus,
So
but
the moment Supreme Court passed the final order, they went to the right court. So we can't say that it is abuse or anything.
lordships are right to that extent. Malus, the only point that I wanted to make for lordship's consideration, I'll leave it at that, is Malus. The Honorable Supreme Court, when it decides the matter, it decides on the existing law. It doesn't pronounce new law. In fact, it says that
It is virtually like, denying the remedy in every case.
Malus.
It is on fact and it's also declaration of law. Both go simultaneously.
Malus.
Thank you.
Malus.
15.
That's great.
Transfer of section. How is section 11 is to be transferred? Where are you getting these ideas?
Transfer place, lads.
Section 11 transfer, you never heard. Heard of section 11 transfers.
Lots of court has not.
You would have made your argument saying that this section 11 is not maintainable.
Yes.
Did you not argue? Because
Why.
Because they should have gone to
Any
the.
opportunity.
That is why clearly your counter affidavit before the High Court is not filed.
Lots of opportunity that given it is very hasty.
So no transfer of section 11 petition. What are you saying?
Lots of.
Where are you getting these ideas?
Lots of arbitrator has been appointed by the other.
Appointed already.
Just recently on 6th half because I filed petition on 23rd.
Then what is the, then it's in.
Lots of, they have no jurisdiction. I am in Delhi.
Then that order, it's not it. Have you filed here?
Lots of just yesterday.
It's a transfer petition.
Yesterday order was passed. I filed this petition on 23rd.
This is anyway to be dismissed.
Lordship, apart from it, Lordship,
60.
Lordship, I may be given opportunity to file a special petition against the order, Lordship.
Who in the world has stopped you?
Lordship, that's right. But other proceedings, Lordship, are pending in Delhi, Lordship, and I have to go all along to Mumbai just to
You
participate.
have made your argument. Next. Mr. Section 9.
Lord, I am a contractor, my lord. I have a 63 crore contract, my lord, to set up a plant to process overburden, my lord, when you extract coal. I have to, my lord, process it and give them sand. My lord. So I was working, my lord. They paid me, my lord, 3.32 crores to start with. After 2 years, my lord, they say we have overpaid you, give it back.
338.
Yeah, it's actually 338, whatever. So, my lord, I went in section 9. The court said their demand to get it back is stayed because it can't be, my lord, work it out today. So that's one thing. I have to, my lord, get additional amounts from them which are undisputed, apart from, my lord, the alleged overpayment. When the matter goes in appeal to the High Court, my lord, does some kind of panchayati, I don't know what it is. What it does is, just look at this, my lord. What I have got.
Interim orders. Tell us, Mr. G. Interim orders are always panchayats, no? That's what you balance the interests of both the parties.
But this is not fair, my lord. Look at this. I went against the demand of overpayment. All right, that I can understand. The court said you keep an FDR. But what I have to get? My lord, I can't, there can't be a double whammy. What I have to get, I must get.
Learned AOR is appearing through.
So there is one more problem. My lord, after this order,
Okay, you take out notice. We'll balance it.
they have disconnected, my lord, the plant also.
We'll balance it. We'll balance it. Take notice. We'll take
You
it up
also
next week.
call it after a week, 10 days, my lord.
Next week. Next
Let's-
week.
Returnable 2 weeks?
Next Friday. Next Friday.
Next Friday.
Very well.
Well, here, well, they are invoking section 79(3)(b, well, which is not at all, well, that's a safe harbor provision for the intermediary to do blocking. And the only thing I have is page 85. My portal is gone.
Similar matters are pending or what?
Plus, one matter, the issue in the, well, it's not identical, but there is an overlap. I'll tell you lots
It's
of what.
pending
There is a
before
rule
chief. I'm aware.
Well, it's rule 16. No, I'll give the detail. It's rule 16.
If it's there, we'll post it.
Yes, Balaji, losses may issue notice and tag it along, no difficulty.
We'll do that solicitor. Or your lordship, yes. Or my lord, I am accept
matters are pending.
notice may
Plus,
not
the
be
only one-
necessary.
That's fine. Balaji.
Sorry?
Yes.
But I am appearing, my lord. Let him give me a copy. Let it be tagged. Notice may not be necessary only for.
Well, let the reply. I'll tell you lots of the difficulty. Today,
I'll file my reply also.
no, but that, Malad, I'm not opposing that. Today, Malad, there is actually my portal is gone. So there is something in the interim which I may need.
We're posting.
Yes,
it.
I am
All
here.
right.
We will
But
upload.
we are not taking it.
All right, all right.
Post along with it. Next.
Grateful.
18. Lord, 18, if your lordship can pass over, my lord, there is one matter being called out.
Well, then,
18.
Mr.
Pass over,
Mine,
pass over.
I would rather finish my arguments now and he can
No, can't be. We don't do.
then also put another date. Well, I'll be.
We'll have to pass
I know
it
after Passover, I'll not be here.
Lord, have it on some other day, my lord, then.
I request one thing. We had both requested last time together. This matter will also put on any Tuesday of a lordship's choice. Well, Monday will be this problem. Sometimes Friday. Any Tuesday of a lordship's choice. Well.
Okay, next Tuesday then.
I'm obliged.
My lord, next Tuesday, my lord, might be our turn, my lord.
The Diwan is also. Both of us are in that 9 judges.
Tuesday next. Tuesday next.
Obliged. Correct.
Please. Time लेते हैं.
Please, my lords.
Item
19, my lords. Here, my lords, we have filed additional documents, including the fact that we are now on the NRC. So in certain orders of this court.
When did you file?
My lords, this is an additional volume.
Post when?
5th, on the 5th.
Does not come on record. Just list it after that. Take it on record.
Please, my lords.
Next. 20.
My lords, I seek a Passover, my lords. Passover, my lords.
Best experience, huh? What's that? You tell us what it is.
My lords, last week your lordships had heard me and your lordship said that.
All right. Last time itself we were to dismiss it, but
My lord.
because your senior was not there.
Yes, my
You are
lord.
repeat.
I don't have instructions to argue it.
You have argued. You have instructions. Then what?
I don't have instructions to argue, my lords. I meant.
Then he should be there. At least last time he wasn't there. How
Yes, my
three
lords.
times? This is the third time, huh?
Profusely apologize, my
It's
lords.
the third time that we are at.
I'm so sorry, my lords.
There's nothing in this. 21.
Yeah, please. Millard, the petition before lordship Millard is a marginal farmer Millard, and the respondent, he has been Millard grabbing the land of the residents of the village, playing all kind of tactics Millard,
Sir, what is
It was a simple case of loan.
answered? Delay 457 days delay.
Milord, for that, Milord, may I
Very serious delay. It's not
submit, Milord, because
particularly when all the courts have gone against
the petitioner, Milord, handed over the papers, complete papers of the case to some learned counsel, Milord, and he had been pursuing it, Milord, thoroughly, but somehow the counsel could not file it, Milord, in time. That's why in February he took the papers.
Particularly when all the courts are against you.
Well, submission is, Milord. That's why. That's why.
600 days delay.
Humble submission is.
On delay, there's no satisfaction, sir. We'll dismiss it.
No, Milord, may I submit? May I draw also kind of attention, Milord? I complete details have been.
What have you done?
Pardon, Milord?
Show us the reasons why.
Please, Lordship.
In spite of
Page 134, Milord, para 6. Petitioner used to diligently follow up with his counsel with respect to the status of.
Just see half a page of the one page.
Pardon,
Nothing.
Milord,
Absolutely
the
nothing. Not
poor
even
fellow could not do
not even
more than that, Milord.
a routine effort of, file
Milord,
moving or nothing.
despite the fact that he had not been only given all the documents to the counsel, but also given the entire fee, the petitioner disheartened, his counsel had not drafted the petition till.
Does it convince you?
Pardon, Milord?
Does that convince you?
No, this is what actually happened. I have satisfied myself also. This is what actually happened. Somehow the counsel could not file the matter.
Even otherwise, a concurrent finding of
Milord, submission is on that, Milord. On that, Milord, you'll kindly see the High Court order, Milord, at page 5, Milord, page 4, other para 5. In fact, the High Court order is in fact without hearing the counsel. High Court order is without hearing the counsel also, Milord.
It's not just High Court, it's a
Well,
trial court.
the submission is, Milord, in fact, this, my specific case right from day one, that the petitioner took loan from the respondent, Milord, and out of that he repaid also 2 lakhs rupees, which were duly received by way of check. It's not oral. By way of check, Milord, payment has been made.
Thank you, sir. Thank you. Dismissed.
Milord, it would be very hard case for the poor fellow.
Next.
There,
22.
So this is that refund amount.
Yeah, what has to be done? Yes, Mr. Shiva.
Milord, only 1 second if I'm permitted.
Yes.
Milord, the order.
It is your application.
My application. Milord, I came forward because after the final judgment, I have become entitled for this amount. And only thing which I wanted to satisfy your lordship for, that this amount of approximately 49 plus K is computed only for us, only in our account. And this is by the order which your lordship passed and the written submission, written submission in the appeal which your lordship decided. This honorable court was pleased to admit the appeal and also directed the applicant to deposit the amount refundable to the respondent number 1, 49.87 crore as the interim measure aforesaid direction this honorable court stands complied with. So there was no dispute on computation. Now this amount has gone up to 60 crore. Because this was up to a particular date. So after the judgment, my lord, in our favor, this amount is to be given to us. And on this amount,
Yes, Shiva.
Lords, 2 points. First, this is an MA in a dismissed matter. It cannot be maintained. There is a judgment of this court which requires how an MA is to be. It's a mandatory. It's a mandatory.
Other point.
It's a mandatory requirement, my lord.
That's not necessary.
Because the circular has been
point?
released by the registry after Justice Pardiwala's judgment that an MA cannot be filed with without a solemn affirmation on oath that it is being filed for XYZ reason. And there is no such affidavit on it.
This is a
on
consequential
record.
order. What's the other point?
Yes, my lords, even a consequential order, an MA cannot be filed. That's a square judgment by Justice Pardiwala, which this registry has adopted. There's a circular which I'm happy to pass on, my lords, and Justice Pardiwala's judgment also.
Is there any other point?
Yes, of course, my lord.
What's that?
Second point is that when the judgment was delivered by the original quorum, the MA before the court, the IA for disbursal before the court was ordered on the last occasion. That is the IA which they're now seeking to reopen it. They're asking the same prayer that has been disposed of already. And on what say so? There should be communication between the registries of 2 judicial bodies, this court and APTEL, to which this court has sent the matter to. There is none such. This is unilateral submission by one side. Some difficulty may be
That initial order copy.
Yes, my lord. Lordship may have the entire set of orders. I'm passing
that
on.
initial order.
Last 2 sets.
doesn't have a copy on the
Please see the order passed by 1st April.
This
is not that return.
How can written submissions be passed on in an MA in a dismissed matter, my lord?
I think you are.
Submission of this court I can pass on.
Why we passed this initial order is we were not very sure who all had deposited the monies at that time.
That remains
passed the
today. That remains
order.
today because the judgment inures to everybody's benefit, and more importantly, the calculation is disputed. It is not admitted. And what have they done? The calculation in the very IA that your lordship had disposed of by way of this order.
When the matter was filed here, we are asking who all had deposited monies? So how many appellants have?
I am the appellant only.
How many respondents have?
Only for us. Only the appellant was directed to deposit.
No, 1 minute.
I have deposited it.
The amount deposited is qua a particular
No,
appellant?
please read the initial order. I will share the initial order.
Shows that.
Please, my lord, first order.
That is what we were unsure of.
Please, my lord. My lordship may have this copy.
Para 3 of this order.
Wait a minute.
So, the first order, just the very first order in this compilation of ROPs.
And this is an appeal that you have filed against
Yes, my lord.
only Green Infra?
Only Green Infra. The second order, my lord.
Just wait, please.
The second order, my lords.
1 minute. It was only one.
28-4 order, my lords. The deposit is a salutary measure to conduct the final hearing. It has nothing to do with
Apart from Green Infra, there were no other.
Everybody is there, 50 respondents. Please see the memo of parties of the court. Yes, my lord.
Please have the
Paper book, memo of parties may be seen. Everybody is a respondent. And it's a salutary measure by this court to conduct the final hearing in the matter.
This is a civil appeal 4495.
For payment to me.
Yeah. All 50 respondents are there.
Para 4.
Lordship has seen order dated 28th April. Passed by my Lord Justice.
With your lordship permission, this order clarifies everything of your lordship. My lord, para 4 says 3 says deposit for them. 4 says other will come up on account is due.
Not for them.
Judge, please don't talk registry of each other, please. Wait a minute, Mr. Mr. We are asking him, you don't interrupt. What is pronounced with
And
no, we don't want this order. We want the initial order.
Yes, my lords. I have passed on a copy 28-4. Lordship may have my compilation of orders which I have just passed on. 28-4 order after the first order as an ad interim measure. That's what your lordship says, para 3. It's not qua any particular respondent at all. That's the order of this court. Lordship has it, my lord. And this was considered in the IA for withdrawal when your lordship disposed it off. And how can it be re-agitated and reopened now?
That was directed to the deposit.
And that too without any communication from Aptel registry.
Mr. Maninder Singh, that's when we passed that order, in fact, after the judgment was over, we are also little unclear to who all it will inure to the benefit. The impugned order is not confined only to Green Infra, right? Just see.
See the direction, my lord.
No, whatever. Forget about our direction.
No, I'm not watching the
But
direction.
when the appeal came here, initially, we asked them to deposit the money, and the money was to be deposited. So many other companies are before us.
Whether this 49 crores is for me or there are other people who have to.
We will not get into that inquiry. We have only
executing court.
In your lordship's order.
Lords, with this court will turn into an.
We are asking him now, please. We don't want double talks in this court.
Lord, with utmost respect, I'm not arguing any law. But the enforcement of your lordship.
See, we are only telling you one thing. The only thing is that when we passed the order, our judge, initially we asked them to, as a condition, deposit the money. After the judgment is over, we were only considering whether it will inure to the benefit of the solitary respondent or many other contesting respondents or not. How are you showing? That's why we are seeing the SLP.
Your lordship order deposit in my case, we can get to
Sure.
Yes, kindly see below this order of 28 for period 25. This order is.
That is the same order your lordship has.
So that this is perfectly, my lord, an authority who has, my lord, now has the, before your lordship who has to pay, is doing everything not to pay. 28th of April, there are two very critical para 3 and para 4.
Yes, as an interim measure, pending disposal of appellant. Appellant, yes.
Appellant is me.
No, apprentice there.
Respondent shall deposit 48.
He is not the only respondent, there are 49 respondents.
I think this is exceeding your limits. You are exceeding your limits.
This is an
We are telling you that
matter.
don't interrupt.
Being
When
listed
he was
within
arguing, we said that don't do that.
Satisfying the registry
Don't do
requirement.
that. Don't do that. We are warning you. Don't do that. Don't do that, Shiva. You are not just new to this court.
Yes, madam.
ये हमारा impugned order है.
Yes.
I was the only appellant.
Upon such deposit, there shall be.
Shall be free of review order. The amount for deposit shall be kept in.
But where is it that confined to you?
In the meanwhile, other respondents have filed their counter affidavit.
That doesn't say so. That doesn't say so.
The direction is for me.
Anyway, where do you want? Okay, tell us one thing. We are not going to disperse it like that. We will either transfer it to the commission to allocate and disperse it to the respective parties or to the APTEL, wherever you want us to do, because we can't get into to whom it is belongs. We won't be the executing court for this. You get your point.
The allowance of the appeal, the interim deposit, which is only for me. There is no further execution.
We don't think we meant it only exclusively for you, Mr.
He's saying.
You've made it, Mr. Made your point. Where do you want us to do to transfer it? You just tell us.
Which is filed before your lordship. Can there be a better evidence?
Which is that written submission? Whose written submission?
There.
All right, sure.
My lord, may I say something?
Page. We'll come back to you. We'll come.
The
Page,
IA which your lordship had already disposed
page.
answers that question.
27.
This is re-agitation of the same IA.
87,
This-
last item, 28th of April 25, your lordship order which I read, now this is the written submission on completion of the argument.
My lordship,
Which
very
paragraph are you reading?
Serial number 27.
Number 27. That is the date of the order, which your lordship passed.
Serial number or para 27?
No, so serial
Number
number.
27 is just out here, this is the written submission which I have handed over.
if we are going into the written submissions and pleadings, it has to go before the original quorum. Let us argue the matter, my lord.
We'll pass the orders. Wait a minute. The Honorable Court was pleased to admit instant civil appeal and directed appellants to.
This is not a pleading.
Refundable also. Here also.
Nobody else.
My lord, that is a pleading. That is not a pleading. It won't substitute. It won't substitute the order of this court.
All right, we'll pass orders on your IA.
My lord,
Well, Shiva, what do you want?
one request, my lords.
Yes, tell us.
Your lordship.
All right, you made your point now.
Your,
We'll make your point. Yes,
your,
tell-
your lordship has disposed of this very argument on 1st April 2026 by way of IA number 172022. In the very same argument, 1st April 2026, your lordship has passed this order, the very same argument.
Yes.
And after it is over, an MA is filed.
An interim order. That 1st April 2026
Six.
order is what?
Yeah, it is after the judgment is passed.
Yes.
After the judgment is passed, the registry listed the matter for disposing of the IA seeking withdrawal for amount. That IA is IA number 172022 of 2025. In that, your lordship passed an order saying, go before APTEL and trash it out. We are not the executing court. 1 week
APTEL
later,
doesn't have the
bank account. My lord, that is an inconvenience at best. A separate head will be maintained, amounts will be taken, whatever, and APTEL doesn't say it. It is their unilateral submission before this court. 10 days later, by way of an MA, which comes to be listed within 5 days, without the
does
affidavit,
anything remain
without
for
the
the
affidavit
APTEL to
contained.
consider? Does anything remain in
Of
APTEL?
course, how to disburse, when to disburse, objections. And of
Disbursing
course,
before
my lord,
commission?
my lord,
Disbursal is before commission or APTEL?
lordship can send it before the forum of first instance, which is the commission, and more importantly, see their calculation. They ask for carrying cost. That IA, when it was disposed of by the court on the last occasion, carrying cost was said it cannot be there. Now what they do, they remove the caption carrying cost, add the amount to B only, and say give us the amount. Please see that it's fraud on the court.
what they have done. Let me show both the IAs. Your lordship
Alright,
will
alright.
realize it. Your lordship will realize, see the amounts.
We will pass orders on the IA.
My lord, there's just a practical difficulty because the APTEL doesn't have an account, it goes into the.
My lord, is that an inconvenience that is to be brought
see,
to the Supreme Court by way of an MA? They will be a.
All right, now we'll pass.
You should say APTEL doesn't have a
We'll
bank.
pass orders.
APTEL should say it.
No, don't say
However
so.
powerful they might be, they cannot substitute the words
Alright,
and
alright,
wisdom of the court also.
We'll pass orders on that.
Just, well, the APRC is not functioning for the last 1.5.
APTEL doesn't have a chairperson. Can it be on oral say so, my lord?
Doesn't matter. We'll pass orders. Next. 23.
Kindly pass it, madam. Please.
What is this matter? EA in the AP.
Yes, madam. There was a half a minute.
What is to be done, Mr. Naswareddy here? What
In
is
the
done?
company petition, my lord, winding up proceedings, a scheme was framed with the consent of all the unsecured creditors. This is one of the item. At that time, the suit was scheme was approved by the
That
High Court.
was EA.
Scheme was approved by the High Court, my lord.
Suitable as a scheme, not.
And this gentleman could not be paid on account of the fact that his suit was pending by the time the scheme was imposed. Now he files an EP. In the EP, we said that this is the.
You catch your breath. You came running or what?
Yes. Came running. Then, well, the only form is 391. Section 391, your lordship kindly see. 391 of 1956 Act, all the.
Not complied with the scheme, right? How do you wriggle out of the fact?
It is paid, my lord.
No. Under the scheme that was granted to you,
Yes, my lord.
you were to pay
4 lakhs.
in some installments between 1st of October 2002 and 1st of September 2004.
Yes, my lord.
That period
Yes.
had gone by and you didn't comply with
No,
the
by that time.
One minute. Right, whatever be the reason. So you then object to he has gone to execution because you have not complied with that. When he has gone to execution,
Yes.
you file an application in 2016.
Yes, my lord. Because EP was pending by that time. EP was pending.
They have been, but why did you not comply with the scheme?
Scheme, well, according to scheme, we have to pay 4 lakhs to him. By that time, the suit was pending. Suit was declared only in 2005. Thereafter, my lord, the EP was filed, and in the meanwhile, they filed this. And once, and amount is deposited, my lord. That 4 lakhs is
after.
Now here,
Mr.
here they say, the liability of the principal is no doubt extinguished. But
you realized what you
pardon?
They didn't execute the decree immediately, which was passed. Decree came to be passed in
2005.
When 2005. Yes,
ma'am.
They didn't do it because the scheme was in operation. So they could have waited you for this. You could have complied with the scheme. Matter would have ended.
They did not.
You didn't comply. So
Yes.
therefore they were forced to file the EP. And in 2016, you are filing this objection.
This petition of
Typical execution objections.
and the amount is deposited, well, amount is paid. That amount is paid.
How much have you paid?
4 lakhs, same amount is paid, my lord. Whatever was
How much is the decree amount?
4 lakhs only. The decree is for a different amount, but subject, this is your lordship may kindly see, the trial court itself took note of the scheme and said this.
See, in 4 installments you are supposed to pay.
No, that is under this trial court decree, your lordship may kindly, page 86. Page 86. Sorry. Page the trial court decree. Just 1 minute. 86. Pages are equal.
Years after, Mr. Vikar. Amount is paid 3 years after.
Amount is paid, my lord. And trial court itself said it shall be subject. This is here it is.
As per it, just check.
Yes.
Please answer this.
Page 96.
My brother is asking you something.
Page 96.
Amount was to be paid from 1/10/2002 till 1/9/2004.
Yes, ma'am.
Right? You have paid it on 30th August 2017.
Yes, ma'am.
After 3 years.
Yes, madam.
That's why.
Yes, madam. And that was paid.
Apply short amount now.
No, your last
You've got a life of how long will you drag it on?
It was
2005 decree.
page 96, madam. Page 96. Page 96, the trial court itself said that it shall be accordance with the scheme.
That's what exactly we are telling you. That scheme you have abandoned.
Yes. No, not everybody. Everybody was paid with this because suit was pending and there was some dispute. It was pending. And today, the executing court as well as high court say the liability of the principal may have been extinguished, but your liability of suit is surviving. That is contrary to section 138 of Contract Act. Because liability of a suit is coextensive.
All others have paid.
What?
All others have paid as per the scheme.
Yes, ma'am.
If you have not paid as per the scheme, what can be done? Others have paid as per the scheme.
As per the scheme only it was paid, man.
Others
Maybe delayed.
that's right. How
There was
fast?
delay.
We understand. Now you have come to the point.
Yes,
finally.
yes. Delay.
Finally
Yes.
you have come to do it. Now the question is,
Yes.
how long the delay? 2004 September you could have completed. You are raising objections in 2016. Then
It's
too late.
No, it may be some reasonable
Very
interest, but
unreasonable.
today
It will be unreasonable to a decree holder to deny him. This
company petition, my lord,
leave
it
it
is.
at that. Leave it at that.
The Lashima kindly see
Thank you.
the hardship because it was under liquidation.
Okay, we have heard.
Everybody was paid, but
We have heard.
no, your Lashima and question of forum, my lord, forum
Leave it.
section half a minute, my lord.
Yes.
Forum for once a scheme is framed under section 391, the only forum is a high court. That 392 and 391 and executing
What
court.
you did after so many years,
Yeah. No,
you could have done again.
that is what forum. Your last kindly see the forum. Because
Okay, Mr. Narasimha, leave it at that. Thank you. Dismissed.
no, your last kindly see today.
Next.
In addition to the 4 lakhs, if I have to
Okay, leave it at that now.
no, because your last kindly only one aspect. Only one aspect.
24. Leave it at that. Leave it at 24.
24 minutes.
Yes.
And may I say, we will withdraw it and we will
What is it?
take the plea in the execution proceedings. Sir.
EP.
In the EP,
Dismissed.
What?
Anyway, after some arguments, Mr. Narasimha, senior counsel, seeks to withdraw. Specially petition, permission granted. We can give you some time to deposit instead of getting into all that.
that's what I am saying.
How much time you will want to give? You tell us.
Time, but subject to adjustability
how
of
much.
at the most it can be interest component. Your last
Whatever it is, you tell us how much time you want to deposit. Close it here itself. We'll give you the-
deposit the interest component. Once the high
whatever is the admitted amount, we are not going to.
admitted is 4 lakhs, my lord. 4 lakhs we paid. Interest component your last may indicate we will pay.
You find out.
Yes, my lord.
What according to the in the EP court, how much is the money to be deposited?
EP is now he is filing for several lakhs, my lord.
Can't adjudicate that.
No. Your last
Then you argue your EP.
There are two things, my lord. EP is for about 20 lakhs. EP is for about 20 lakhs.
And after some argument, Mr. So seeks to withdraw the special petition. Permission granted. SLP is dismissed as withdrawn.
Much-
You are
Interest component.
That's perhaps the better way to do it.
The other side is ready. We are prepared ready to pay the interest instead of cutting short the litigation, my lord.
Let us go there.
Much obliged.
24.
Item 24 minutes. An objection to the constitution of the arbitral tribunal is taken in 11.6. It travels up to this court. My lords pass an order upholding the jurisdiction of the arbitrator appointed under 11.6.
A lot of judgments are there on.
Yes, my lord. I can just pass on my lord's judgment in CU, my lords. I just hand it over. Lordships and my lords, in LG Chaudhary, my lords, it was said that in matters where awards have been passed will not be unsettled. Here is a case where the same objection was taken in 11.6, carried up to this honorable court. Your lordships upheld the tribunal on the ground that the tribunal, on the date 11.6 was invoked, there was no tribunal constituted under the act. That is in 2008. In 2024, my lords, the High Court sets aside on the ground that the arbitral tribunal lacked jurisdiction because
What have we done in the conclusion? Only oppose the alternative amount.
Let me just see
Commercial court.
paragraph 9, my lords, page 3.
But this is only some
Order.
kind of a
Yes, my lord, I can
142
pass on the
order.
entire compilation also, my lord.
This order is a 142 order.
Yes, my lord. Just see, my lords, the order passed by my lords at page 195 of the SLP paper book.
I think what needs to be done is this question seems to be arising quite often. It's about the applicability of the act. Now, what did the High Court say?
The High Court was only on the ground that Justice Nariman's judgment says that the tribunal constituted under the MP statute is the body before which all
It
arbitration
is allowed, no? So it says about res judicata.
Res
There is no res judicata.
Yes, ma'am. Now please see page 6 of their counter affidavit for a moment.
What is res judicata? Earlier round, huh?
Then 5 appointments.
You keep the question of law open. Will allow this.
Yes,
Lords,
ma'am.
I am
Will allow this.
humbly opposing, my lords. I'll explain why.
Oh, sorry, we have to ask you.
My lords. My lords, section 20 of the Chhattisgarh Adhiniyam very clearly says that upon constitution of the tribunal under that act, my lords, in spite of, irrespective, notwithstanding anything in the Arbitration Act, the jurisdiction of civil court is barred, my lord. Now, the constitution.
All that is over.
No, my lords, not
Never
over.
raised
Not
before the arbitrator.
admittedly, my lords, the facts are admitted, my lords.
You didn't raise before the arbitrator, number one.
My lords, so
Did you raise before the arbitrator?
in 34 I have raised.
There is already
No,
a
my lords,
judgment.
but in 11 I raised, in before the Supreme Court in the challenge I raised, and LG Chaudhary in para 15 and 16 very clearly says that in cases where this objection has been taken.
Okay.
No, my
There
lords,
is a
but
question of the
11
High Court.
my lords,
There is 37 saying that's not res judicata and permit you to allow it, will allow.
Let me just have 11(6)(a) of the Arbitration Act for a moment, my lords. The judgment say that 11 is only a facilitative provision, my lords, and 11(6)(a)
How much is
says,
the amount?
About 97 lakhs.
but my lords, this will have a bearing on many other matters.
That will keep it, that'll keep it, that will keep it open.
The plea is abandoned. It is admitted in the counter affidavit, paragraph 17.
Because the issue is constitution. The constitution was already constituted. The tribunal was constituted on 1st March 2005. That's the difficulty.
Judgment, the clause is extracted.
Let's have
The
this.
relevant paragraphs of
If I lose in section 11, the
Right, this
fact
now
is
they-
this, that if
will restore section 37, you go and argue it on merits.
very well, my lord.
You argue it on merits.
All contentions to be left open, my lord.
Divorce this, my lords.
Huh?
Except for this contention.
Naturally, why will we allow this again?
Because in another matter arising from Madhya Pradesh, it has happened, your lordships relegated it back and same objection was taken by the state. And again, we are before, my lords.
I'll explain why, because this
Not
question of law has to be left open, my lords. Otherwise, this will have a bearing.
That will keep it open, but this case, it's final.
But my lords,
Specially petition, leave granted, specially petition is arises out of the judgment and order passed by the High Court of Chhattisgarh at Bilaspur in arbitration number 22 of 2021. Full stop. The short facts leading to filing of the present appeal are that an application filed on behalf of the appellant under section 11 of the Arbitration and Conciliation Act was considered by the High Court, and by its order dated 16/9/2005, an arbitrator came to be appointed for adjudication of the disputes between the parties. Full stop. The arbitral proceedings culminated. You challenged the section 11 order also.
State challenged it.
I did, and I lost.
Before that, you write, the appointment of arbitrator was challenged by the state on the ground that the arbitral proceedings are to be governed by
the MP.
The MP.
Actually, Chhattisgarh in this case.
Yes.
Chhattisgarh.
Madhyastham Adhikaran Adhiniyam 1983.
1983, full stop. This court considered the matter and by its order dated 22/1/2028 dismissed the appeal of the state. Which page is that? Is there a reason?
That is at page 195.
Just let us see that one.
The operative is at page 200.
195. Paper book there, 24. 195.
195.
Yes, okay. Oh, this is a detailed order.
Detailed order. Initially, it was stayed, leave granted, and then by detailed order.
Which one, some portions there.
Page 200, my lord, is the relevant.
के बाद of क्या बचता है?
Page 200, put. Yes, my lords, page 200. Last paragraph, having heard learned counsel for the, there's only.
Having heard. No, about that rejection of that plea relating to Adhinayam and all that, is there a reference?
But that reference, my lord, should find in the
order passed by this court.
At the bottom of page 196, my lords.
Yes.
Having heard.
वो तो है. वो तो है. Anything else apart from that, having heard?
Moving application, arbitration tribunal not available. Therefore, you could not remove.
अधिनियम के बारे में कुछ कहो.
The High Court had rejected the
Having heard
Because that tribunal was not functional.
Functional on the date my 11/6 was preferred.
Okay,
But
ये बस है.
There is a factual, my lords, there is factual correction in this, that the order is passed under section 11 by the High Court on 16/9. The tribunal was constituted on 1st March 2005 and became functional on 2nd September 2005. Here's the factual difference.
Award, my lords, this objection.
No, my lords, the facts have to be stated.
Paragraph 2, page 200 में ये इतना बस है. With the dismissal of the special petition, paragraph, the arbitral proceedings commenced and culminated in an award passed on 21/3/2008. Full stop. The state challenged the arbitral award by raising objections under section 34, which was considered by the district court, right?
Yes, 34 was dismissed.
256.
That is at 256.
256. Considered by the
district judge Sarguja.
Sarguja 256 में है. Considered on merits. Considered on merits and dismissed and considered and dismissed on merits. Full stop. The state preferred an appeal under section 37 of the Arbitration Act, which came to be allowed by the order impugned before us. Full stop. The impugned order, instead of considering the legality and validity of the award, as upheld by the district court under section 34, has proceeded to decide on the maintainability of the arbitral proceedings itself. Full stop. We are of the opinion that it was not permissible for the High Court to revisit the decisions taken by the High Court on 16/9/2005 and also of that of this court, also that of this court on 22/1/2008. The conclusion of the High Court that the earlier judgments are not res judicata is not correct in our opinion. The courts having ruled on the fact that section 11 application is maintainable and such a decision has attained its finality. Revisiting the maintainability and setting aside the award on the ground of jurisdictional error is incorrect. Then ये क्या है? Okay. Paragraph maybe, we will only say that we are not expressing an we are not to be understood. Don't say like that. Just say that the decision, the jurisdiction, it is confined only to works matter, no?
Yes, lords.
Works contract.
Works contract. Yes.
The jurisdiction of that the act, the jurisdiction of the arbitral proceedings to be confined with respect to works contract under the Adhinayam is not under question. Is not under question. This question of law, this question is anyway covered by the decisions of this court. Give us those two judgments. However, in the facts of the present case, as the High Court as well as the Supreme Court has directed that the arbitral proceedings shall be on the basis of the decision taken under Section 11 petition, we are of the opinion that the High Court could not have set aside the orders dated 16/9/2005 and 2/1/2008. The question of law raised by the learned counsel for the state is kept open for being considered in an appropriate case.
Also, my lord, section 11, I have a concern, not about this matter.
Open.
Because section 11, my lord, is because the issue of jurisdiction, etc., in spite of whatever is there in section 11, my lord, is left open. That also may be observed.
The decision where the parties has attained finality and as such could not have been reopened. In this way, the matter appeal has to be allowed. And we allow the appeal, set aside the judgment and order passed by the High Court. The second appeal, the number lena, the number lelo, arbitration number 22 of 2011 is restored to its original number. The division bench of the High Court. The High Court shall now proceed to hear the Section 37 petition on merits and decide in accordance with law. With these directions, the civil appeals stand disposed of. We have kept all the questions of law open.
It comes up before a single judge, my lord.
Yeah, that's why we said High Court.
And my lord, my last request. Yes, my lord.
You got judge only.
It will go to a single judge, my lord. Well, there's one, it's a 2011 section 37. If my lords can request the High Court to.
Okay. In view of the fact that the appeals have been, the arbitration is of the year 2005, request the High Court to take up and dispose of the Section 37 application as expeditiously as possible, preferably within a period of four months from today.
Most obliged. Much obliged.
Next.
May please, my lords. Lords, it is a case of a border security force and the absenteeism is around 6 months. The court has said that you reinstate him in service and give him notional back pay. Well, it's this kind of
We've told you to take instructions.
Well, we
Either you reinstate him without back wages or give him some monetary.
For the peculiar reason that he all along he was aware that the proceedings are going on. In his own counter affidavit, 6 months of unauthorized absence, overstaying the leave. And what he's
Findings are
that we did not give him adequate opportunity. On that ground, my lords may kindly remand it back. We will consider.
No, not that. Finding is that it is not unauthorized absence, it's overstay.
Yes, we are saying it is overstaying of leave. That is also, my lords, an error which the courts have committed. It is, our case is also that it is overstaying of leave. He never came back for the first time when he came back. This is 2000, my lords, kindly have 2000.
We are giving you a way out.
It's in disciplined forces. How can we give, this will set a precedent that in all these cases where people overstay, they don't come back.
How much time did he work?
He worked only from 2013. He joined in
2013 February.
And he went on leave on 4th of October 2014. So, it is hardly any time that he's worked from February till not even a year. And then he goes on, he never returns. And then he says, I went for a tona tota.
Could you say that's what she says is right?
Not
hardly
1 year.
It's not a normal employment. But we will direct you to pay some money for it. But you contested without any.
I've been fighting.
Tell us.
These kind of cases, my lord.
Tell us. We are here hearing you. Tell us.
It's just a cook, my lord. It's a David versus Goliath fighting since 10 years.
That's right.
And the convening order, my lords, was conducted on Sunday. No opportunity given. Even in my statutory appeal, my lords, it is a mechanical order.
How do you justify your absence? Tell us.
That's the only thing. There are medical records.
That's it.
And I was suffering with infectious hepatitis. I have annexed those in the counter, my lords.
Please have page 43.
Will remand it.
Please have
So
page 43.
there are genuine
You are
sufficient
willing to
causes, my
give him
lords.
an opportunity, right? So
So if that is the case, he says that he was not represented, we will consider it again. We
Lords, remanding back after 10 years.
Provided you have a small case on merit, sir. Provided you work for hardly few days, so.
page 43, he says that he received the letter of 17 January 2015, but he writes to us only in July, that too after 6 months.
In May, I joined.
That I had jaundice, etc. But in
There are
the
factual
letter that he has attached,
May I
he
join?
says that I had gone to a tantric for a tona totka.
It doesn't need so much of hearing.
Well, I am only saying that this being a
Okay, all happens only in small sparrows. On them only all this will come. Big
Well,
pigs
it's
all
only for the precedent's sake we are arguing.
My lords, there has been total disregard of natural
monetary
justice.
compensation. We will direct you to make some payment.
Let's we'll consider and pass appropriate orders. Let him produce those medical records because
Everything
we've
is
not seen them. We don't know whether those
Because
records are
Medical
even
records were
genuine.
there in front.
You won't have.
Whether those
how many-
records are
In
genuine.
statutory appeal, medical records
Almost,
were annexed.
almost 14 years have passed by, yeah, in the meanwhile.
Plus, we
But
will
still
do it in a
27 years
time-bound
are
manner.
still 27 years are left, my lords. I am just 33, and I am a cook, my lords, and cook doesn't forget how to cook. So on that aspect, at least, my lords.
Plus, we'll do it in a time-bound manner.
Demand करते हैं. All right, pass कर लें, lunch में pass कर लें. We'll pass orders. Next.
Grateful. I'm only pressing one point. Let it not be a
Small
precedent.
don't
I'm
fight so much.
anything, but this being a disciplined force, today it is a cook, tomorrow it may be a
He's not a
jawan.
discipline. He is a cook. He's a cook.
Let's-
He's not a jawan. He's not a one who
Tomorrow it can be because
There was sufficient genuine.
rules are applicable on everyone.
try to balance it.
My lords.
Oblige, my lords. Oblige.
24. Fine.
Let's 26 is a batch of 7 matters and Learned AG is leading us in this matter. He may kindly be unmuted.
1 minute, madam.
Please.
Yes.
Well, it's Learned AG is leading us. This is a batch of 7 matters.
Pursuant to your lordship's last March, we have filed 2 separate affidavits. One is on 10th of April and the other is on 7th. The second one may not be on record, but we have specifically denied that no one pursuant to the Honorable High Court's order has been granted the tender. The impugned tender notice is of 13th of, that was the thing which the other side was alleging.
Yes, we will hear all of these matters, right?
My lord, I have filed a reply to their affidavit. I think, my lord, the learned advocate general.
How many matters are here?
Lord, eight matters.
Hear them.
But all are covered by an earlier order of your lordship.
I just needed to bring to your lordship's notice that similar SLP was there.
Same tender.
Lordships, when your lordships were hearing this in the last
Same
occasion,
batch.
lordships were noting a fact that state has implemented the direction in respect of various other persons. Your lordships wanted the state to file an affidavit. State said we have not done in water department, but the other departments we have implemented the orders of the High Court.
That is
I have
not
filed
correct.
an affidavit.
That's a separate.
Giving 7 instances, my lord, where orders passed even prior to my order. Yes, my lord. 7 instances where the state has implemented. So they choose, my lord. If they like the contractor, they're implementing. If they don't like us, they don't want to implement.
That is not the case, my lord. The High Court, before acceptance of the bid, passes it and directs that you grant it.
Hear it now itself.
Well, his Learned AG is ready.
Okay. How many? We'll just pass it over. We'll finish other matters and then.
Yes. Can it be taken up in some other day? My lord, can it be then taken up in some other day?
Some other day, my lords.
चलो ठीक है, after 2 weeks लगा देना, Tuesday के दिन लगाओ. Put it on a Tuesday.
Grateful, man.
My lords.
Yes, below.
My lords, it can be any Wednesday, my lords.
Wednesday and Thursday, no.
Tuesday.
What? Maybe 26. No. You don't give me a date. Date नहीं किया है.
We'll give you a date, we'll give you.
Yes, my
It can't be Wednesday, Thursday, it's only Tuesday or Friday.
Very well.
Or even a Monday we'll do it.
Yes.
Party will.
Yes, ma'am.
27?
Yes, my lord.
Yeah, please.
Yeah.
Yes, please.
Suit for specific
Yes.
purposes.
I am for the defendant, Manoj. What had happened, Manoj? Manoj, may I hear this matter on Tuesday, or may I start, Manoj?
Tell us
Yes,
what
Manoj.
it is.
Manoj, may I have?
GT Grish versus
Yes, Manoj.
Superaido is there. Agreement of sale.
Yes, Manoj. Agreement to sale also, Manoj, and there are 2-3 factors more that they've, apart from Gitesh Manoj, what they had done is they filed a specific suit for specific
Agreement
problems.
of sale was done even before. We wanted to see that allotment letter.
Yes, Manoj. Allotment letter is that.
Okay. Okay.
Yes, Manoj. Page
If
37.
you show us that there was some kind of a prohibition
Apart from
in
that,
the allotment letter,
yes,
then you will succeed. If there is no such prohibition, then there's a difficulty because you have entered into an agreement of sale and there are concurrent findings of both the courts.
No,
In
no,
the allotment letter, if there is a clause on transfer of the allotment, then they can't make a claim. And agreement of sale is give us the allotment date.
allotment date is Manoj
16/5.
16/5/96, and the agreement to sell is prior that Manoj 24th March, 27th
Still,
March.
even then we can perhaps
then, Manoj,
hold in your favor.
yes.
But show us that.
Yes, Manoj. Manoj, may I have page 37. There is a
I know. How do you
11,
do it?
clause 11.
There is a clause, you can't just allotment is a public, it's the largest, no? You can't just take it and sell it off to third parties. And then allotment is a sale itself, is that? How does it?
No.
How does it work? Just tell us.
Manoj, may I have page 11, page 37, clause 11.
Yes, show us the
The land, yes, it is my, or should, it is the original copy.
Doesn't matter.
The land building shall continue to be going to the authority until the entire consideration money, together with interest and other documents, if any,
Land building shall
continue to be with the authority plus until the entire consideration money
continue to be
continue
to the authority.
Yes, Manoj.
Authority until
The entire consideration money, together with interest and other amount, if any, due to authority on account of sale of such land or building, or both is paid. So my
Is there any prohibition against sale for within a
Yes.
period?
You shall have no right to transfer by way of sale.
You shall have no
Right of way of right to transfer by way of sale, gift, mortgage, or otherwise
Reading 11.
the plot of building or any right, title, or interest therein till the full price is paid to the authority. So, Manoj, the full price was paid after 4 years, Manoj. 4 or 5 years.
Lord, may I assist for a moment?
And then, Manoj, yes, okay. This is the first one, and that is the judgment of GT Gitesh, Manoj. There's specific bar. And then, Manoj, they filed.
It's not a bar, a specific bar.
And Manoj, they filed a suit after they kept quiet for 3 years, Manoj. They filed a suit 4 days before the
agreement of sale is 96.
96, Manoj.
After 3 years, they filed the suit.
Yes, Manoj.
Still in limit.
And Manoj, may see agreement to sell says 1,72,000, whereas the original price here in the allotment is 2,40,000. Manoj, there are other judgments also, Manoj, I want to rely on.
So, what does the agreement of sale say? Shows that agreement.
Yes, Manoj.
That I will buy, I will be getting allotment. So, therefore, the moment I get allotment,
No.
I'll
That
sell
is
it,
not
is
there.
it?
That is not there, Manoj. Manoj may see that it is
in reference that I have been already allotted, and even the allotment number has been added. Even the allotment.
Leave granted. We'll admit the case.
But
We'll admit it.
I want to submit something, my lord, for a moment.
Just tell us.
At page 50, he himself has transferred this plot in favor of his son after this agreement. So he said, well,
Son is
it
son.
could be transferred, my lord, but I say it could be transferred.
Son is something, sale is another thing. That doesn't mean that.
And my lord, it is done with the
It is like
permission of the
saying
Huda. We apply to the Huda, Huda grants permission for allotment, reallotment.
We walk through the.
Sir, for 30 years, I am in the courts.
No matter. Leave that.
Obliged.
Next.
Last time your lordship was kind enough, my lord, to give opportunity.
70
Notice was, I am for the respondent, my lord. So limited to the question of settlement, my lord.
Sir.
So we had a talk with them, my lord, and your lordship was of the view that amount of 50 lakhs would be reasonable, my lord. We leave it to your lordship, my lord, in view of facts of this case. So particularly, my lord, we had a meeting, but now they have to, 50 lakhs we are.
What have you agreed?
My lord, 50 lakhs we have it.
50 lakhs.
Yes.
So therefore, you are the plaintiff, right?
Yes, my lord.
Yeah, High Court. 50 lakhs. The High Court has.
My lord, may I just point out?
50
यार उसके चक्कर में ये भी ना चला जाए.
So you will pay him full and final settlement. You will pay him 50 lakhs more.
My lord, they will pay.
They will pay you 50
That
lakhs
is what
more.
They are saying they will pay us 50 lakhs. I may take a minute if your lordship may permit me, my lord.
The decree is modified.
Though, my lord, I am faced with 3 concurrent findings and everything.
No, that's right. That's the amount he will.
They will pay us 50 lakhs. So that, my lord, it's a settlement. We'll accept that one. To buy peace, my lord, we'll accept it.
So you will allot 50 lakhs, okay? Leave granted. Especially petition. No, leave granted. The petitioner is the plaintiff in a suit for specific performance of an when is that agreement of sale dated 28/5/1990. The trial court decreed the suit on 30/7/1995, and the same came to be upheld concurrently by the High Court as well by the
First appellate court and second.
we don't know. Just check what the appellate court by the so and so court being in first appeal as well as the High Court in second appeal. Full stop. The only variation in the decree passed by the High Court is in the direction of the learned judge in the direction that the plaintiff is to pay 70 times more than the agreed amount, full stop. The agreed amount for sale is rupees 1.1 crore 92 lakhs. No, sorry. 1,92,000.
1990.
1 lakh in the year
1990.
1990. 70 times of the said amount.
No, my lord, 70 times of the balance amount, my lord.
70 times the balance amount comes to
1 crore 17 lakh.
One comes to 1 crore 17 lakhs. Full stop.
27,800.
27,800. Full stop. At the stage of admission, on our suggestion that the parties could settle the matter instead of seeking an adjudication, the learned counsel for the petitioner as well as the respondents have informed that they have arrived at an amicable settlement. Full stop. It is agreed between them that an amount of 50 lakhs will be paid by the plaintiff to the defendant, petitioner plaintiff to the defendant. In view of the statement of the learned counsel, we dispose of the present leave granted karke kala na, we dispose of the appeal, directing the petitioner plaintiff to pay an amount of 50 lakh within a period of
3 months.
3 months from today. Stop. Upon such payment, Its sale deed is not executed, right? EP is pending.
No, possession is with us. EP is pending, my lord.
It is admitted fact that the defendant is the plaintiff, who is in possession?
We are in possession.
Respondents.
The respondents, defendants are in possession of the property.
And at the time of receiving the money, we'll hand over the possession to them.
And
So
also
there will be no scope of any confusion or doubt.
within
also
3
agree with
months.
the
will be,
sale
no?
date, my lord.
We said 3 months, but that's the outer limit. Immediately after completion of the payment, the sale deed will be executed
And possession.
and possession will be handed over. So, in view of the above, appeal stands disposed of in terms of the above. There shall be no order as to pass.
My lord, just one more submission. My lord, at the directions of the Honorable High Court, my lord, in the meantime, since we were having with the possession, we were depositing mean profit in the court, my lord. So that will withdraw now, my lord, which is a small amount of 5-6 lakhs, my lord. We'll withdraw that. That your lordship may kindly.
That may be. The mean profits deposited
by the respondent here.
by the respondent may be withdrawn.
So grateful.
Before the court, deposited before the court.
So grateful.
The mean profits deposited by the respondent in the court pending disposal of the second appeal shall be
withdrawn by us.
Returned.
By the respondent. So grateful.
Same thing. 29. Respondent number 1 is a public authority.
Patriarchal tribunal, whether it's this thing comes under the.
Yes, Purushottam, we have
Please,
appointed you as an amicus. Yes,
Lord,
My
I
lords.
appointed my friend as the amicus because the petitioner had died before your lordship had appointed.
My lords, the note has been filed, my lords, before my lords. And my lords, we have just categorized it into 5 parts, my lords. The issues for adjudication, the factual backdrop, legal framework, and the submissions on merits. And
who is the petitioner actually?
It's
my lord, she is a lady.
The petitioner,
Yeah,
well, it's now this.
We'll just Purushottam, we'll just hearing.
No, please.
For a minute. No, be there.
Please, my lords, I'm here. I'm here, my lord.
I was
We'll be able to conclude today. We'll do it today or?
It may not be possible to finish it because the lordship want to hear it.
It requires to be heard, ballots.
Okay.
Section 8 is very clear and 2H is very. Who is a public authority?
He is a public.
My lords, I have just tried to categorize, my lords, the main 3 issues within my respectful submission, my lords, before my lords.
It is not a public authority. I could.
Yes.
Because are neither constituted or established by a law of parliament or by a law of the legislature or government.
Section 12.
Yeah. No, section 8.
Section 8 of
Section
the.
8. Yes, my lord. My lords, the.
2H.
Yeah.
The definition is 2H.
Please, my lords.
We'll hear it at non-miscellaneous day.
My lords, just 2 more issues
File
with my
as a-
lords' permission I had just framed, my lords. One is whether a body whose decision alter the civil status and of a public marriage and my lords' dissolution can avoid the scrutiny with regard to the records.
Certainly.
And my lords, the third one is whether the RTI queries which are posed in the present case, whether they come under the purview of a personal information, my lords. So, my lords, there the
gave a
privacy
copy to
angle
Mr.
will
Ranjit
also-
Kumar?
My lords, it has been served on both the parties. My lords.
My lords, will permit
Great,
me
sir.
also to.
Yes, sure.
file
Sure.
my
Of course,
submission
sure.
for
We're going to hear you.
oblige.
We're going to hear all of you.
Grateful, my lord.
We'll
Grateful.
give a date. Final disposal के लिए.
But it's a personal information which was caught under the RTI.
Yeah.
All marriages and all divorces and how are the appointment made? All that will be done. Lordship.
The question doesn't arise. You're right.
Your Lordship, in item 38,
Personal privacy.
petitioner is seeking passover, Your Lordship.
Last chance.
We are seeking passover. Main counsel is in another court, Your Lordship.
What is to be done in this?
In the last occasion, must have done to find the status of the respondent, the complainant. They haven't filed any.
We made.
Anyway, Passover.
As a party.
Transfer petition, है ना?
Complainant को implicate.
Has the complainant come? We have implemented the complainant. Have you served on them? Service is complete on the complainant. The whole purpose will be lost when we can't do this without the complainant. That's why we asked you to bring the
Your
complainant.
Lordship, we made the complainant as a party.
then
Your Lordship,
served.
just pass over my main
Service
counsel.
complete on the complainant. Huh? Complainant. File the proof of service. We'll wait for some time and then we'll list it.
Gratefully.
Okay. बाद में कर लेना छुट्टी के बाद. Yes.
Your Lordship, in item 31.
The respondent is posted nowadays in West Bengal. Joint application has to be filed. Lordship may have it 140 under 140.
Joint application, we asked you to file.
Yes, Lordship may have it in July. We will file it because he has gone in the election duty.
All right.
So by that time, everything is over.
Await filing of the joint application.
Deeply.
No, list after filing of the joint.
My lords, EC was granted in July 2021 and operations were commenced in September 2021, after which the NGT order declared mining illegal in March.
IA for direction?
We have not been able to get the EC renewed because of the NGT order, whereas
That depends upon whether there are any violation. Who's from MOF?
I'm appearing for the original.
MOF. You served on the MOF.
MOF.
They will have to tell us what the position is. So serve a copy on the MOF. A copy of the special petition and as well as the interlocutory application may be served on on central agency. Full stop. Okay. Which will be passed on to MOF Kalena, Ministry of so and so. Give a copy of them, copy on them, list on so and so.
I'm obliged.
Obliged.
May I please, please. My lords, item 33, civil appeal, my lords, emanating.
Appeal should come up for hearing now.
Yes, my lord.
My lords, listed for hearing. The only thing is, my lords, I've
Yes,
moved an interim IA.
To file, my lord.
What has happened in this matter, my lords, this is a appeal by home buyers, my lords. They were earlier before the NCDRC.
That percentage, right? Or a statutory.
No,
appeal.
that is fine. While my lords decide that, my lords, all I'm saying is there are 6 home buyers out of this, in which case they say that they have the occupancy certificate. They don't have it for the remaining. I'm saying at least they can take possession without prejudice to rights and contentions of the parties. That's all I'm seeking in my IA. While my lords decides what compensation is payable to me.
Possession you should get.
Yes, my lords, that's all.
What is the direction of NCDRC?
The direction of the NCDRC,
6% delay compensation and delivery of possession.
Exactly. I am
NCDRC direction.
Delivery
That's
of
only
possession.
you have. Wait a minute. Sorry. Only you have come in appeal.
I've come in appeal, my lords, primarily because I say that the compensation.
Whatever you wanted more compensation.
That's correct. Because I have a different.
The possession is concerned, they will have to give the possession.
That's so my interim application is that only, my lords.
What is that application?
My lords, that's IA 121.
What for? What's the direction?
121942. I'm seeking, let them give me possession without prejudice to rights and conditions.
Ask them.
My lord, 2 things, my lord. Out of 36 persons, my lord, 19 came here, my lord. Out of 19, 6 have already settled. They have to remaining 13, my lord, settled. 1 taken compensation also. So remaining, my lord, 14 here, my lord. They are 14 persons, my lord. They want to take possession. We have been calling them. They are not coming to take possession, my lord.
Okay, go and take.
2,000 home buyers have taken their residing peacefully.
Go and take.
Out of 14, my lords, 8 flats, they don't have the occupancy
So
certificate.
whatever-
So that I may not be able to take legal possession today.
That's
6, I am saying.
1 minute. So far as the directions are concerned,
Yes.
We will say that appeal admitted only as regards the payment of additional compensation.
No, my lord, there are other issues also. There are no direction as far as what will happen to those home buyers where occupancy certificate is not.
That was not the question before the NCDRC, my lord.
Then you do one thing. You go and file you will just say appeal admitted. No interim order. Listen to us. No interim order. You listen to us.
Yes, my lord.
The petitioner will be entitled to execute the judgment and decree of the National Consumer Dispute Redressal Commission. Go and
Very
file an EP and get it executed.
Without prejudice?
Yes, yes, of course. Of course. We have protected you to this extent.
Very well.
Go and execute it.
Very well. Very well.
Much
I'm deeply obliged. I'm deeply obliged, my lords.
Please, my lord, Anand Kumar Misra, senior counsel, has to argue this case. My lord, today morning he said that I am unable to argue this matter due to the high grade of fever, my lord.
No, no,
Kindly
doesn't
keep it on Monday or next Friday, my lord.
Okay, next, whenever you want. We'll have it some other day.
Monday,
Some other day.
Monday,
Monday
or Friday.
Whenever you want, Friday, next Friday.
Oblige.
35 is really
35 seeking a passover, seeking a short passover, my lords.
We'll post for final disposal.
tested on NMDs earlier also.
That's okay.
Post for final disposal.
Yeah.
Post for final disposal. Yeah, we list it.
Okay.
Lords had orally indicated that we won't be disturbed, but if they can be accommodated, that's all. On that.
Yes.
Will final disposal. We thought it will get settled, but looks like that there's nothing like that.
Finally, fixed apropos your lordship queries, my lord.
We'll hear it then. Next. We'll give a date.
Is my lords giving a date?
But we have kept those posts vacant because of your lordship order.
Okay.
So those posts are lying vacant, my lord, for some time.
My lords, we will also make some submissions on eligibility.
Says not that there are vacancies. But there are vacancies.
Post for final disposal. We'll give a date. We'll give a date.
Don't lie vacant.
Yes. We'll do it.
Lordship.
Grateful.
Lordships, on item number 36,
Please.
I am the lead petitioner. Lordship, these are bench matters, 36.
Yes. Next item.
Lord,
36.
Lordships, in item number 36, they are bench matters, and I am the lead petitioner.
All right. We'll hear you. Next.
There are other matters.
Yesterday we circulated a note, mentioned and circulated a note.
Which item, Sanjay?
36 only.
36.
36.4.
Oh, that,
Yeah.
yes.
The clinical, yes. Now, my only submission is, I read the note which has been circulated by London Attorney General.
I think you lordship did
Yeah.
not have the benefit of the note.
We didn't have the benefit.
Let me just say one thing. The note deals with 9.2. 9.2 is fixation of rates in difference. 9.2 is concerned, that is under challenge, and we are not, because that has to be heard. We have no problem. What the note which I have circulated is with regard to other issues. I don't think London Attorney General has any problem, like even displaying of rates, etc. Whatever they are charging today, all those things should be a patient chart.
Whatever.
Yes.
We'll fix a date and then we'll hear all of you.
Lordship, the 9-2, it will take only 2-3 minutes in case.
We'll hear all of you, sir. We are going to fix a date and going to hear.
Lot of consultation happened in the meanwhile. State governments were almost persuaded to come down, but they still have some hesitation. The minister himself had consultations. I was part of some consultation. Kindly hear it sometime.
Of course.
Early July.
The hearing.
What do you want?
The regulation 9 is in two parts. 9.1 is only for display of rate. On that, there is no opposition from anybody, and yet on display.
That's my note.
One second.
Please wait. Let him speak. Please wait.
Let a person make a submission before you start interrupting. 9.1 reads thus: every clinical establishment shall display the rates charged for each type of service provided and facilities available for the benefit of the patient. Conspicuous place in the local as well as English. That's all. Now, I said that there is no opposition to this. There are certain.
Section 9.1.
Milord, in my note also.
It's rule 9.1. No? It's rule 9.1.
My note.
Attorney, what do you say about 9.1?
We are.
Just ask.
Vacancy can be
Let me-
implemented.
Only counsel to whom we are asking, they will speak. Just wait for a minute. We will ask everyone.
I'll make a point in 3 seconds.
Yes.
On there are certain petitions which have sought to challenge the constitutional validity of 9.2. None of those petitions challenge 9.1. When I said that nobody has opposed 9.1, well, I mean that there has to be some legal opposition of some sort.
We got your point. Can we ask others? We got your,
There can't be. If
we got your point.
I'm saying your lordship should impose this immediately. How can they display? That's all.
Only,
We've heard
I
it.
may
We'll
have
ask them.
one sentence, my lord. Lordships have my note. I think that note which I circulated, lordships
That
have.
9.1 point.
Yes, 9.1 point, my lord.
What is your point?
Yes, there are 3 points, my
You are
lord.
agreeing with him?
Yes, yes, of course.
We are asking,
my lord.
we are going to ask, we are going to ask those who are opposing it.
There are
Well,
two or
Who is opposing it?
There are 2 or 3 more points, my lord. That's why I am saying.
Well,
My point in addition to that is that there are minimum standards and facilities for services which have been, my lord, prepared by them, by the ministry. Now they have to be notified only. So I'm asking that they should be notified, and the counter affidavit, they say that this has to be notified. So, my lord, that's number 1. Number 2 is,
If you are expanding, this is what.
no,
Mr.
my lord,
Steve
this is
Using
something.
says is rather simple because it's a statute or a rule which is coming to force. It needs to be enforced unless there is some opposition. We're going to ask that.
Yeah, lordships are right.
Give us a minute. Give us a minute. We'll ask. Attorney, what do you say about this?
Well, it's 9.1 also I'm opposing, Lordship. I'll put my note into it.
1 minute. We'll ask. We'll come back to you after we heard the.
252.
What do you say about 9.1 part of it? You are with the petitioners?
252. There are only few states which pass a resolution, and those states which did not pass a resolution will have to adopt the law. Many of them have not adopted this law. There is no lack
lot of them have not adopted.
uniformity is there. Therefore, but then as far as central government is concerned, we go by our rules.
That's right. Your rules, according to you, these are rules which wherever they have come into force, they have to be implemented.
That's right.
Yes, Mr. Nafide?
So we are opposing imposition of.
On what ground?
That it is integrally connected with 9.2.
No.
Therefore, the entire petition has to be heard. And then if your lordship finds.
This 9.1 has come into force from when?
2012 Lordship.
2012.
From 2012, it has not been implemented.
None of these things have been done from, my lord.
No, it has been notified.
It has not been.
Yes, yes.
It has not.
Indian Medical Association has filed an affidavit before your lordship saying we have no objection to 9.1.
My lord, what is,
We'll ask those who are opposing, no?
No,
Well, it's,
Indian, that's
no,
To permit us, we will ask.
But my-
because
Those who are opposing, we will have to ask. Otherwise, we are in your favor.
I appear for the IMA, they are all independent petitioners. They are not my subsidiaries or I am not their
Well-
parent. That's incorrect.
Malad, I appear in 36.6 is
You are
a
for whom?
association
You are
for
for the
health
hospital.
providers. Malad, we are opposing this for the reason the act provides for minimum standard, not for maximum standards. Today procedure is not only blood
So to
testing. and
challenge
all.
these rules somewhere.
So there are,
You challenge these rules somewhere.
I have, viris have been challenged.
Yeah.
Yes,
into
in my petition. This is a substantive petition which is 36.6.
You are under 32 before us.
Lordship, I
Lord,
submit. Lordship,
all-
only 9.
Viris have been
I
challenged.
have ID on. You are asking her in front of you.
Please, Malad.
You are under 32 petition.
Yes, Malad. These
Now,
are
you are
all,
also under 32 petition.
they're all 32 petitions before my lords.
my lord,
But
only one,
Let's do one thing.
my lord, only one.
Hear
my
everything
lord, one
together,
clarification.
pass on.
All these petitions, the challenge is only on 3.2 rule.
9.
9.2, sorry, 9.2. There is no challenge of other rules. And because, my lord, the rules are not.
May I suggest? Yes.
So what we will do, attorney, what we propose to do,
Yes.
what we propose to do is, so far as these rules are concerned, we will examine them in detail.
Please, Malad.
But whether these rules should be a stay, there should be a stay or not, we will consider. We'll just
No, Lord,
only on the limited question as to whether they should be implemented or not is the only question.
My lord, there is already an order by your lordships on 14th of August.
Correct.
Your lordships have said, pending disposal of writ petitions, we clarify the clinical establishment rules 2012 that have been notified have not been stayed by this court. As of today, they partake the character of applicable law.
Then,
That
what more is there?
it is not being done.
That's okay, then enforcement is a different matter. We are
That's
not.
why I was pointing out. those
That's
states
then
will-
post for final disposal, all right. Clear all of you now.
Correct.
पोस्ट फॉर फाइनल डिस्पोजल वो ना एक आने वाला ट्यूसडे में लगा देना
Late July.
सेकंड ट्यूसडे खुलता है ना जुलाई में Second Tuesday, second. Yes, yes.
On and on, Mrs.
No, no,
Give that
Yes,
date.
yeah.
Give that date.
In which month, sir?
We are giving it. 21st of July.
Deeply obliged. Members.
It has to be
Members,
heard,
I
my lord.
first request if in the meantime, wherever replies are not filed, if that could be.
What
That's
is it that we can do? You should call.
And we could have the benefit of the AG's note.
I don't mind being amicus. For the
Mr. Nafde.
opportunity of, let us have some orderly way of going.
All of you, we are not talking about
Yes.
this matter. Mr. Nafde, that Bombay matter, where you had appeared, and you raised a question of law, file a review in that.
Very good.
Right.
Okay.
वो देखते हैं बाद में
Please, my lord. My lord, the petitioner was, my lord, illegally terminated, my lord, in 2010, my lord. 2020, the Honorable High Court, my lord, had.
You are the owner. No, sorry.
No.
कौन सा 28 है? 28 है?
37.
Huh?
37.
37. Yes, you were terminated.
Yes, my lord. I am terminated in 2010, my lord. 2014, my termination was confirmed by the divisional officer, my lord. I filed a writ petition. In the writ petition, my lord.
Set aside in
Yes,
2020.
set aside, not merely on the ground that, my lord, that under.
No back wages.
Double one. But back wages not allowed, my lord.
50% back wages.
I filed, my lord, the writ of petition.
That's a very reasonable order.
My lord, the what?
That's a. Huh? Kelawala, the other judgments, no work, no pay applies against
I am
you.
relying on.
Even that much you won't get.
If see, my lord, the rule, I am relying upon the rule which has been framed by, my learned friends relying upon the rule, my lord. Kindly see the counter affidavit, my lord, page number 47 and 8, my lord. The what rule says? Directly, my lord, draw my lord's attention on page number 47, which says that, my lord, if the employee has been legally terminated, my lord, he deserve and entitled to have, my lord, that the back wages 100% and full back wages along with the consequences, the benefit.
10 years have passed. 10 years have passed.
Yes, my lord, the 2000, even, my lord,
Look
I
at
even
that.
retired in 2023. I only,
All gone.
my lord, because restate could not.
Whatever the money they have deposited, have you taken that money or not?
Rupees, my lord, is deposited but not educated because, my lord, is only
Take-
50%. I was, my lord,
See, your problem is that your case is 284 days delay. We can just dismiss it on that ground.
my lord,
But you are better off. We will not do that. We will not do that. We will say that the amount deposited, you will be permitted to withdraw immediately. Yes?
My instructions are that he is paid, my lord, but be that as it
Has
is,
he
my lords.
withdrawn?
My instructions are that he is paid.
The deposit.
Either ways, my lords, if not, my lords may say that if not paid, it may be paid.
Okay.
My lord, only one submission is not. I am at this stage, my restatement could not be because, my lord, I am already 62 years age, my lord. I has been deprived from the service. I was not deliberate, my lord, evaded from the service. The whole termination was illegal without not only on ground of reasonable opportunity was not provided, even the fundamental.
Your termination is not under question, sir.
Yes.
The only question is your reinstatement with 50% back wages or none at all is the question.
Yes, my lord.
So we are saying that it's not none at all. 50% should be good enough. So they have deposited the 50%.
But, my lord, in continuum of judgment, even, my lord, I am relying on judgment.
All right, leave it.
Do where, my
There are
lord,
also either side, no? So specially petition is dismissed. However, there shall be direction that the 50% direction that the 50% of back wages directed to be deposited by the division bench must be paid to the petitioner. Paid, if not, they already do you have instructions whether you got the
He
money
has
back?
deposited the amount as far as the, my lord, withdrawal is concerned. I'm not so no.
My lords may
We
say
will
it's
just
not
say
paid,
that.
my lord. Let's not.
As direction, my lord,
The
along with the interest.
the amount deposited by the state can be withdrawn by the petitioner. Was taken. Next.
Grateful, man.
My lord, I'm seeking
One page.
little Passover, my lord.
Passover maybe.
My lord,
Well, there is one matter at 2:30, but
Which
my
one?
lord,
Board of
here,
Trustees.
here we found out our rejoinder, my lord, needs to be filed.
Okay.
Number one. Number two, our assessment is that if your lordships can consider having it on some non-miscellaneous day. It might take some time, not very long time.
my lord, after vacation, summer vacation, my lord. Is it all right?
All right. Give it post for final disposal.
Please, Your Lordship.
Rejoinder, if any, may be filed in the meanwhile.
The Board of Port Trust has filed the rejoinder. Only the Union of
No,
Yes.
Union has to file. Union.
Right. Same order.
Obliged, Your Lordship.
I am so.
Lords, in item 39, the state has filed their affidavit saying that the post has been withdrawn. Lords, the post does not remain with the recruiting agency. However, the department might.
What is this about?
Lord, this is very short.
Person visual disability.
Please not, please not. Lord,
Oh, you wrongly wrote as.
inadvertently, I filled no, Lords.
The High Court says it can't be corrected.
Please not.
Consider on compassionate grounds. What happened?
Well, sir, I filed my reply. Lordship may kindly see my reply. I filed my reply, my lords. Lordship may kindly.
Have you considered as per the High Court judgment? Have you done?
Yes. I am not sure on that, whether we have.
Has it been considered?
Yes, I'm not sure on that.
But now, what is this appointment? At what stage is that? Everything must have been over. We are talking about a advertisement of 2012.
Yes, and the posts are also not there. That's what I
What
have to
is
say.
it
The
that
post
Remains with the department, Lords. Two of the, in fact, Lords, one of the successful candidates.
Now, it's too late, isn't it?
Lords, one of
You're
the.
for whom?
There is a difficulty so far as I am concerned. My lord, I was appointed.
Oh, you are appointed.
I was there in the appointment list, but thereafter, my lord, there is no stay, nothing. But I have not been given posting. I am waiting.
Because of this pending list.
Pending case only.
No, Lords, they failed to.
Why don't you appoint him? Who stopped you from appointing him? And High Court's judgment is 2024.
That's right. I had to go to CAT also.
Yes,
CAT
it
also.
was because, my lords.
At least one person will be appointed.
That's right.
Because nobody is getting appointed.
Manage the difficulties, there are no posts now as of now.
Anyway, that you will have to bound. You are bound to you having given. We'll dismiss this. Dismissed.
Lordship.
Your lordship may direct them to appoint respondent number 3, my lord.
That's okay. We will not say.
Your lordship.
Yes.
Your lord.
We will say dismiss it.
Yes.
Consequential action may be undertaken.
Yes.
Great.
Consequential action will follow.
Lordship.
Next.
Lord, would your lordship say respondent number 3 because that's an admitted.
You don't know what the position is. What do you say, Mr. Kawasaki?
Lords, just 1 point for your Lordship consideration.
Lordships have said consequential action.
Consequential action will follow.
Lord, just 1 point.
That's enough. That's enough, my lords. He can already.
Follow it up. Follow it up.
Lord,
carefully.
just one submission for your Lordship consideration. This objection of notification they are taking, they have not taken before the Honorable High Court. This is prior to filing of their writ petition, Lord.
I said so last time.
We can't grant relief.
I said so last time.
Next.
So many things have changed there.
Item
Let's-
40.
May please.
Number 40, we want to file a reply, Your Lordship. We need some time to file the reply.
Plus, matter actually should be tagged. I'll tell your lordships why. The matter needs to be tagged, Willows, because in our respectful submission, what's happened here is very simple. They filed an MSME claim for a contract which
just that we have to file the relevant documents.
No, I appreciate that. Just give me 1 minute. I'll
Don't
just
interrupt.
Plus, they filed an MSME claim for a contract
That's
which
the
had,
award.
which had predated their registration. Now, when I pointed out,
You take objection at the before the 80. Did you take the objection?
I did. So I raised the
Show us.
territorial objection. Well, that your lordship will
Show us your objection before the 80.
Yes. Well, your lordship will see P2. In fact, this is an ex parte award.
No, your objection before.
Yes.
Did you?
Well, your lordship may come to P2.
You filed a reply before the.
I did.
You
I
raised your.
I raised it there. So now the point was this. Then I went in writ. Writ, they recognize that Shilpi is in my favor because Shilpi is very clear. You can't do it. Now
that's about registration part.
That's correct. But Manoj, to be very fair, your lordships in NBCC has to some extent doubted the correctness of Shilpi and referred it. So Manoj, in many ways, this matter then also technically should get referred. So that
What do you want us to do?
But I have no difficulty. Your lordships will tag it along with NBCC. I'll give your lordships one order. Manoj, both matters, in fact, have been set out. Can we just hand over this? One option is that, Manoj, or we just wait it out.
You know.
Where is this? The two matters tagged.
We should get it. What? Yes.
There's one
Post
possible.
along with that batch of matters.
I'm deeply grateful. We'll give the diary number, Lords. We'll certainly provide that. Lords, one last request, Lords. Then let there be stay of execution.
Why don't you settle it in the
I'll
meanwhile?
certainly try. It's only that mounting interest, Lords.
That's why it's better for both of you to
I'll certainly try that.
go for mediation.
I have to need.
Pending disposal of that.
We'll certainly try that, Lords. We'll certainly try that.
Single judge dismissed, no?
No,
The,
Lords. Writ
okay, you find the writ is also referred to.
The whole, that's right. So that in fact the question of writ has also been referred.
It suits you to keep this matter pending because you have suffered an award.
I'll certainly try and
then
settle.
if we lose, then you will have a huge liability.
In fact, Lords, I must tell my
You
Lord.
will have a huge liability.
I appreciate that.
Why don't you go for mediation?
So, Lords, we did try on one occasion in a connected matter, which in fact which didn't work itself out. Lords, can I make one respectful suggestion? Lords, your Lordships have passed that order. I will personally try and speak to them because your Lordships is right. Because what happens is this compounded monthly at literally 3 times the
Just
rate.
heard one other back.
It is very, very.
Back breaking. So it will be better that you settle it.
I'll certainly.
How much is the arbitral award? 1.96?
No, so it's 1.96 plus one more. What's happened is about 2.5.
But doesn't matter. That's all. Once it goes to arbitration, mediation, you can get it settled.
It's gone.
You have instructions. Shall we refer to mediation?
Your Lordship, I have no issues if matter has to be went for mediation. I have no issues.
But I have no difficulty. We can certainly.
We'll try it.
We will certainly try it. Can I just make one respectful suggestion? Correct. No, my suggestion is I'll certainly try mediation. Your Lordship.
Okay, you work, you come and mention to us. This we have anyway posted along with that.
Yes.
If you can get instructions, you mention to us, we will refer to mediation.
Certainly. I'm deeply grateful.
What's T1?
May it please your Lordships, I beg to appear for the petitioner. This is a contempt. Your Lordship's last order of 7th April 26. There is no compliance, my lords. Please have a look at your Lordship's order.
The partial compliance of it, out of 7 lakhs due, I have paid 3 lakhs rupees, another 3.5 lakhs.
Directed, if there is no compliance, the Commissioner of Police should secure presence of the contemnors.
Possession did you get?
The police have been completely assisting the contemnors, my lords. In the last day also, I made a submission. When they were breaking the structures.
Did you get possession? Don't convert us into an executive court.
No, my lords.
Get possession.
Possession has been given. Your Lordships have recorded that.
About money, how much did you get?
7 out of 7 lakhs, I paid 3 lakh rupees.
Mr. So-and-so, learned senior counsel, please see the last order.
No, we remember that.
Yes, my lords.
It's in front of us.
Yes, my lords.
So
please see paragraph
go
3.
ahead and execute it, Raghavendra.
My lords, that I will do.
Compliance of our order where the possession has already been handed over to the respondent. Also, we are also informed that 3 out of 7 lakhs has already been paid. Full stop. The petitioner will be entitled to initiate proceedings for execution for the balance amount and also for damages. Damages
yes,
if the property has been also for damages. Just leave it at that.
My lords may not say so because they
You will of course say that. You will of course say that because your colleague is saying that you have not only delayed it but you have handed over damage.
My lords, what they had given was a piece of land, my lords.
No, that's part of the decree. I'm sorry.
We have removed the building and certain lifts and all which
you have not expressed any opinion on the merits of the matter. It is for the court.
appear for daughters.
So examine the case and decide in accordance with merits.
I appear for daughters, my lord.
Kept it open. Kept it open. With this, the content petition stands disposed of.
Very well.
40. Where are we going from?
Suri had to be here.
Yes, we'll pass it over. What report is that? Oh, mediation report, okay. क्या है? What is? We don't know.
As for the decree. Sorry,
Subjected to few conditions.
Have you seen it?
no, I have not.
No.
We'll give you a copy of the mediation report. But why?
Do we have a copy? No, we don't have a copy.
That 2-3.
1 minute, huh? After.
We have a copy.
Mediation report will be circulated to the parties. Have a look at it. We'll take it up next week.
Can be done now itself, my lord, if we had, lordships have the time. I don't think it'll take more than 5 minutes.
Ah, of course. If you are all
Subject to your lordship.
you want us to pass it over or take it up tomorrow?
The lordships may have it on Monday.
Monday, take it. Have a look at it.
I'll do that.
I think parties will naturally be knowing what has happened,
But it may be,
but you may not know. Have a look at it.
it may be posted on Wednesday, Monday.
All right.
Very-
Wednesday.
very-
Wednesday is the final hearing day. Anyway, this is the
It'll probably
spot
take
matter.
about 5
Wednesday,
minutes, my lord. If my learned friend is not inconvenienced on Monday, let it be on Monday. It'll get over on Monday.
5 minutes, it won't take anything. It's for your sake that we will wanting it to be circulated. Otherwise, it won't take any time for us. There's nothing for us. Have a look at it. We'll take it up on
Very,
Monday.
very gracious in giving us a very long road to see that the matter is settled.
Hmm.
I think it has been settled. It
Very
just
nice.
requires a tweak. I'll request Mr. Suri also to be here if necessary.
Don't embarrass them.
Very,
We are here. We'll
Very-
further it out.
very great.
My lord, a letter's been circulated
So
on
now,
the response.
42 था ना ये? इसको ना report बोलना.
My lord, the letter's been circulated, my lord.
As per the letter.
Lordship, we have filed the counter in the matter in the morning itself. So Lordship may have it in probably next week if.
But I'm seeking some,
Convenient.
I have not seen the copy of what they filed
Have a look
today.
at
They
it.
have filed in the morning.
I have not, but he has told me that he's filed it today. Manoj, I'm seeking some time to file a rejoinder.
The request of both the parties. छुट्टी के बाद लगा. Next.
I believe a letter has been circulated, my lord. The only request is,
letter.
the only request is, my lord, could it be before the vacations, my lords?
We'll try.
Service matter is there.
We'll try and see if what the dates are available. We'll try and accommodate.
My lord,
What do
of
you think?
course, there can't be any objection to the request for adjournment. But my lords, can the recruitment then be placed on hold until then? Until the next date, my lords.
Next date.
Your lordship, there is
One error. Give it.
yes, one error in last order, your lordships.
Says 157, there are 513.
Yes,
It is
Your Lordship.
representing
All different parties, your lordship. Because your lordships, the equities are like
150.
No, your lordship.
157.
Is what your lordships.
Your lordship, there was
They
some
were the people who were being represented by.
157 vacancies, is it?
Yes, Manoj.
We said 157 vacancies.
Yes, Manoj. Actually,
Candidates, lordships,
your lordship,
candidates, but candidates.
Lordship, it was
before your
disputed.
All of you know about it.
It was disputed, your lordship.
All right, all right.
state.
My lords, we all have additional candidates
No, don't.
who are covered by the same
It's a
issue.
non-issue. We are all there. We'll consider it. No issue.
please, Manoj, we don't want to be shut out. That's about the problem.
My lords, could that small change possibly be made? Because then if they are taking time to bring it on record, could they look at that number of vacancies?
We'll see, we'll see.
Lordships, may I make a suggestion? Lordships may say that an error
46.
has been pointed out, which your lordships will consider in the next.
It is
week.
disputed, your lordship.
Say that.
We'll say it next. We'll consider
Yes,
it next.
yes, your lordships may just note that in order.
Yes,
that we
yes. I've
pointed
noted
out-
it on my.
Yes, your lordships, that we pointed out the error, that's it.
Sure, sure.
Lordships,
46.
giving a date.
My lords, is date this side of the vacation?
Yes.
So grateful.
Obliged. Your lordship, I seek an adjournment in this matter.
Last week में लगाना.
Yes. Your lordship, I seek an adjournment.
Yes.
Yeah, my senior is.
You want an adjournment?
Yes, sir. My senior is facing personal difficulties, and I have informed.
इसमें कुछ है ही नहीं है इसमें. Arbitration award can be a financial debt or not. ठीक है, छुट्टी के बाद लगा जयंत. Next.
Please, please.
Notice was issued. The matter arising out of CIRP. 3 years, my lord, the RP has been controlling. And in fact, there has been no
3 years,
extension
what
order by the NCLT.
You are a suspended director.
Suspended director.
Let's the issue was the condemnation. The condemnation.
I've explained that in my additional documents.
Well, he is capable of.
It's statutory balance.
He's capable of doing it.
Let me just have my additional documents.
Invoices raised.
Para 7, page 3 of my additional documents. I explained that the initial order was dispatched only on 17 September. Just have page 3.
Yeah, just.
Para 7. Well, the date of the order is 29th August 2025.
What's your best point? Just tell us.
Well, my best point is that in fact the principal amount of 1.12 crores they are claiming quay me.
Is there a stay here of CIRP?
No, I subject to correction.
And what happened to the CIRP?
No, my lord, that was ordered in 2023. No extension granted by the NCLT.
What stage is the CIRP in?
No, nothing. They have not been able to deal with anything.
The name of the company was struck off, because they did not comply, Therefore, the appeal is pending before NCLT for restoration of the name.
So CIRP has failed.
No,
So it's gone to liquidation.
No, not yet. When the order of CRP was passed, the company's name was struck off, because of their defaults, Then appeal is pending by the RP before the NCLT for restoration. On the last date of hearing, I have pointed out to my lords, that the condemnation of delay, there is a statutory bar, After 15 days, it's been filed,
No, we are simply asking about. This is against the section 9.
Yes.
It's against it. It is arising out of section 9.
That's
so
right.
This matter is actually infructuous then.
It's not, Lord. If my lord were to determine
the
fact the invocation of CIRP itself was wrong, then the entire process goes. Lord, insofar as the
That is an
company is
independent process, the name of the company being struck off.
Yes, my lord, that is an independent process. So whoever is at the helm of affairs, whether it is me or the RP, will have to take efforts to undo that process before the ROC. What I'm saying, my lord, this
RP.
No, I represent the OC. The operational creditor.
You're from the what's the position?
The application is pending. It is listed on 30.
Because there is no stay here.
No.
If there is no stay here, why is CIRP not proceeding further?
There is only one creditor who is respondent number 1 here. There is no financial creditor in the company. But this is the status. There are no assets of.
So how do you want to take forward that CIRP? It is a time-bound process, no?
My lord, even insofar as the assets of the
No,
company.
we'll hear you.
I'm so sorry.
If it's a time-bound process, so what? I mean, that's just continues like that without any.
The name has to be restored, my lord. Then thereafter, the further proceedings can be taken.
Name.
Now the name of the company has been struck off. For that, the application before NCLT is pending, which is listed on 13th of July.
So therefore, this will also will await. If the company's name is struck off, there is no company in existence then, name of the company.
This will go parallelly, Manoj. This will go parallelly because what I'm arguing here is that the invocation of CIRP itself is wrong. My star point is, my lord, the principal amount that they're claiming koi me is 1.12 crores. This 1.12 crores was in a situation where I was supposed to be the intermediary and I was supposed to receive the invoice and then paid thereafter to ADPL. Now, ADPL has paid them directly 1.12 crores. That is what I've stated so in my written submission, stated so in my additional documents also. So my star point is the fact that, in fact, as on date when the Section 9 was filed, there was no debt due. So the invocation of CIRP itself was wrong.
What does the High Court say? What does the NCLT say?
But the NCLAT unfortunately doesn't deal with this argument. They didn't go into the merits at all.
You file an affidavit indicating the status of the affairs. RP is directed to file a detailed affidavit indicating the state of affairs. RP is directed to, the RP shall file a detailed affidavit indicating the state of affairs. In the meanwhile, post this matter, for final disposal, we will hear you. Because there is no stay here.
May I just
So
indicate,
this is
can I
rather.
just indicate one more thing? Not insofar
Oh,
as
1
the
minute.
assets.
How much is the delay?
Matlab, the delay is 37 days, matlab, which is actually, matlab,
According to me, it's 13 days.
matlab, I've held it,
I'll
matlab,
explain that.
matlab, were there in the bench itself.
But this is not a bar.
Matlab, it is under matlab, IBC, matlab, 45 plus
If it were to be beyond
45 plus 15. Matlab, sir, correct, matlab.
Janakiram, what is the judgment?
The judgment is Nagarajan.
Nagarajan.
And A. Rajendra.
Have you seen that?
Repeatedly,
I've seen that.
the
I agree with that proposition. I just have a dispute on facts. What I'm saying is that my appeal was filed on the 58th day. The bar is after 60 days. I have filed it in the
You're saying that you are
58th.
well within time.
I am well within the condonable.
Their application, matlab, itself says 37 days delay. Matlab. And matlab, may just see the
That is the
application for a
office
moment.
report.
Matlab.
That is
What was that application?
Matlab, I'm so grateful. Matlab, may just have the IA. Matlab. Matlab, the IA is matlab, P2770. Matlab,
You are talking about the appeal here, right?
absolutely, matlab. The application filed by them seeking condemnation of delay. Matlab.
Here, appeal before the Supreme Court.
It's the
Yes,
office report
matlab.
prepared by the
Matlab, page is 3. Yes, matlab, civil appeal. The page is 354. Matlab. The copy supplied to us.
354.
Para 2, matlab, they explain the delay. Matlab. That
is
it is submitted that the delay in filing civil appeal is not intentional but is on account of obtaining all the case.
That by itself is not a reason, but then you tell us the date of the judgment.
Plus the date of the judgment is 29th of August 25.
From there,
and
you
they file
calculate
it.
How many days? What is the limitation?
45, 62-1 and 62-2 says 15 days can condone.
45 plus 15.
Yes.
Yes.
Okay.
So
70 days.
45 would expire on 30.
60 days. 60 days.
60 days.
60 days.
It's been filed on 19th of November, admittedly by them.
45 will be 19th of?
45 would be 13th October.
13th October.
15 days would be 28th October.
13th October. And 15 will be?
28th October.
28th October.
And they filed it admittedly on 19th November before my loss.
19th November.
That is 37 days delay. They say so in the application itself. And
it is from the date of the order. That's
from the date of the order. And they were
Nagaraj says that it is not.
I'm so very grateful.
The date Nagaraj says from the date of the.
I'm so, and they were present there before.
I've explained it.
Tell us.
I've explained it. Lord, the date of the order is August.
29th of August. Calculate first.
What I've
45
said
days
so
from
in
that.
my additional documents, my lord, we just have.
No,
page
just
3.
calculate and tell us. 20th
Yes.
of August.
No, there's no dispute on calculation. I am saying that the order was dispatched only on 17th September.
Nagaraj is complete clear on the point.
No, it is.
Nagaraj says on the date of the judgment.
Yes, but the date of the judgment as when it is received.
No.
It has to be.
No, just see Nagaraj.
Of course. No,
see Nagaraj. There has been update from the date of the.
And they were present there when the judgment was pronounced. And they filed.
Nagaraj, if I am not wrong, it says from the date of the judgment. That's how the point of distinction. Just check. Open up. It's not from the date of the receipt. I may be wrong, but have a look.
A. Rajendra is also there and Rajan is also there. I have the copies of the
Shreyesh, that won't work like that. They have drawn it. There are some paragraphs in Nagaraj on the certified copy. I can just place that before my lords. Because that is what we are trying to claim.
The date of the judgment, Shreyesh?
Yes, my lord.
There's no doubt about that. That's why we were thinking of referring Nagaraj to a larger bench.
And the rules of NCLAT says
in Nagaraj, I'm just reading out. The appellant, having failed to apply for a certified copy, rendered the appeal filed before the NCLAT is clearly barred by limitation. That's one of the observations of Nagaraj.
The date of the judgment, salient aspects, so and so, an appeal.
The relevant would be my first 16-point round of now.
Come straight to the relevant portion.
31 to 33 would be relevant then.
Tara 31.
31 to 33. Yes.
And why all so many paragraphs? Just say where the answer to the two issues is set aside in judgment. When we
Malaj may just have 33 the conclusion.
33. That's exactly.
It is
When will the clock for calculating the limitation period run for proceedings under IPC? And in the annexation of certificate mandatory for this so and so. Exactly, Suresh, your question is answered here.
Therefore,
Must be based on a harmonious interpretation given in the IBC. The code itself is an overriding effect. Section 6162 consciously omits the requirement of the limitation being computed from the date when the order is made available to the aggregate party. The contradiction to 40 so and so so and so. The aggrieved party is expected to exercise upon the exercise diligent and apply for a certified copy upon pronouncement of the order.
Yes.
It seeks to assail in consonance with the requirement under the act.
So that's what I'm saying, Malad.
So from the pronouncement,
the copy only on 22nd September.
Last line of this, it is not open, Malaj, to a person aggrieved by the order to under IBC to await the receipt of a free certified copy. Under section 423 of Companies Act, read with rule 50 of
okay, it should be calculated from the date of
limitation
judgment. It's very clear. It's calculated from the date of the judgment. Are you in or out?
And what's
not fairly, if I would submit, Malad, I'm not in. But I am saying that I received the copy on 22nd September, so therefore I'm calculating the limitation from that day.
No, it can't.
If I calculate it from that day, then I'm within.
You are out. You are out. Can't be helped. That's why I asked the Nagaraj to be referred to a larger bench. Dismissed.
Malad, can I at least then request that maybe I can place the relevant document as to when I applied for the certified copy, when I got that certified copy?
That's irrelevant. Just see that. That's irrelevant.
But what
In
you're saying
terms
is-
they pronounce from the date of the pronouncement of the judgment.
But there are two aspects to it. Malad. There is a free copy that is made available by the NCLAT. Then there is a certified copy that you apply for. What they say here at Placitum G at para 33 is that section 12(2) of the Limitation Act allows for an exclusion of the time requisite for
Judgment is
getting a
clear.
copy of the decree.
Next.
great.
48.
Grateful, man.
Milord, it's an afternoon. I
Hold on,
apologize,
before you-
Milord. And the issue involved is very sensitive,
Hold on.
Milords.
Hold on, this
Milord-
matter before my sister begins it.
Is Supreme Court.
Hold on, before my sister. Hold on,
Milords,
before my sister begins, I wish to bring to your lordship's notice the fact that the judgment on the basis of which the impugned judgment is passed.
Milord,
Is
there is
also
a
under
petitioner
challenge. It
as
is
well.
pending in pending
what are you
report
saying?
13. I say, lordships, that this impugned judgment refers to the judgment to rely upon while passing this order, lordships. That judgment is also under challenge before this honorable court.
Right.
Next dated 29th of May. My lord may hear it after that. That will be.
All right. But let us just see.
I'm sorry. I'm pointing that out. Process. The impugned judgment is at page 1 process. And the judgment which was referred to, one also says, page 3 process. Upendra Kaur Malhotra versus Captain Tegjit Singh Malhotra process.
तेरा 11-25 का पेज नंबर बताओ.
498.
Also heard.
Please.
Yes,
correct.
There is that it can't be withdrawn promptly or something. Once you give a consent, once a party gives the consent to 13B proceeding, it can't be withdrawn.
Grateful, Milords, yes.
Which is the
Milords, I will just come to that, Milords, but I would like to tell the facts primarily. It's a very sensitive issue, Milords. I want to get into the facts first. I want to hear.
Give us that judgment. We'll have a look at the judgment. We'll take it up on Monday.
No, Milords, before that, another judgment is there, Milords.
Give us those.
Please, Milords. I'm comparison.
ये आइटम 48 नहीं सर ये क्या हुआ मेरा
Milords, there's a constitution bench judgment by this court. Shilpa Shailesh versus
Shilpa
Varun
Shailesh.
Srinivasan. Grateful, Milords.
that we know no
Yes. Your Lordships have a compilation, Milords. Milords, I request you to kindly come to page 80 of my compilation.
Shilpa Shailesh ka hai. You are right, Shilpa.
Para 63, Milords. I would like to read it. That the marriage has irretrievably broken down. Page 80, Milords. Para 63.
80.
Page 80, Milords, of the compilation I've handed over. That the marriage has, shall I read it, Milord?
Yes.
Please, Milord. That the marriage has irretrievably broken down is to be factually determined and firmly established, Milord. This is what the court says. I will take your Lordship to the application under 142 which I have filed, but before that I'll just read the grounds, Milords, and the factors which need to be considered. For this, several factors are to be considered, such as the period of time the parties had cohabited after marriage.
Okay.
So the present marriage. Yes, Milord.
Yes.
Now the present marriage, it was in 2000.
One minute. What is the problem? You want some time?
No, I don't want time. I'm ready with the arguments also. Yes.
Yeah.
But I simply wanted to point out that the judgment which is impugned before this honorable court martial refers to the judgment relied upon. So that judgment is also under challenge before another bench martial. The question here is not a withdrawal martial. The judgment has been.
Which is the matter which is pending?
Milords, I am sorry. They are also hell-bent at giving me divorce. She's found a counterclaim, Milords. What purpose?
Page number 3 of the impugned judgment martials. Page number.
Letter complete.
Grateful,
Letter
Milords.
complete. Yes,
Just 1 minute.
Yeah, so.
For Milords, I'll read para 63.
Actually, आप जो कह रहे हैं वो my brother has.
Milords, I will just get the citation.
नहीं हो सकता ना?
ये आया ना वो वाला. हाँ. Citation बताओ. Milords, that is Dhananjay Rathi versus Ruchika Rathi.
What does that say?
Milords, if the compromise has been agreed upon, and the first motion has been signed, the wife cannot step back.
That's right.
Brother, yes, Milords.
Then there will be a problem with the High Court
it's
judgment.
not only confined to that. There's a child involved. There's this constant. There is accusation of threat of the father being a threat to the son. So I want your Lordships to.
Post on Monday. What is the other one apart from Dhananjay Rathi?
And the other is, Milords, I'm relying on two judgments. They are there in my compilation, Milords. Shilpa Sailesh versus Varun Srinivasan, Milords. And the second, which actually relates to the core issue in the matter, that is DNA testing. The paternity has never been questioned by the father, and the wife is insisting upon the DNA test. That is, Milords, Van Rathnam versus Milan Joseph, Milords.
That is number 3, okay.
Yes, Milords. And even the first one talks about Article 142, Rinku Baheti versus Sandesh Sharda, Milords.
That we know.
Yes, great.
No, this one we wanted to say Dhananjay.
Dhananjay Rathi versus Ruchika Rathi, and the citation is, I'll just hand over, Milords.
Ruchika Rathi. What is the other one you are saying?
Please, Milords. One is this Shilpa Sailesh versus Varun Srinivasan.
So you are only talking about Dhananjay.
Dhananjay, yes, Milords.
Post on Monday.
Friday, no?
Monday.
Lordships.
Check
up. Just one request, if Friday, because he's
Friday.
Grateful, Milords. Up on the board. Grateful. I'll give that.
We have moved the letter in this matter to file a counter, Milords.
Yes, sir. क्या करना है नहीं कर सकते.
Yes.
As per the letter. उसमें भी letter है. Even letter.
With item 51, I'm requesting one thing. Can it be taken up?
Can it be taken post vacation?
Yes, next.
52 my lords coming up after notice. They filed a counter.
Go ahead.
52 minutes.
Respondent's application for excess tax refund.
The issue is, my lords, under section 119, we issue instructions. What the High Court has held, and that's the primary legal issue, the High Court has held that under section 119, you can't prescribe a period of limitation. And that's the basis on which the refund, despite being beyond that period of limitation, has been allowed.
240 page judgment.
That's not the primary case. The primary case is... my lords, unfortunately, unlike my friend, I didn't appear in the High Court. I am confined by what the High Court judgment says. And that is the basis on which the High Court has ruled against us. Saying that under 119, you don't have the power to do that.
Come back after lunch. This, what do? We'll post for final disposal.
And it can be disposed of on any convenient date. It might take a little time.
It's a limitation issue, so there's no point taking leave.
It's a
limitation is only there for one of the years, and that is only a period of delay of 1 year. If my circular is to be taken to be binding. For the other years, it is within time.
Started hearing explained.
That's exactly what I said. It's beyond limitation.
We'll come back. There are brief. Is that we thought we will extend that benefit to him.
But he is the guarantor, he is the beneficiary, 70 lakhs.
Such an old man.
70 lakhs has been taken.
At this stage, what are
70 lakhs and he has not paid back the money.
But what we are saying is that
Look at his age.
And my lords, in any way, my lords will recall that the High Court has anyway
only one thing.
the amount
We were considering the age of that person. How old is he? Tell us.
66.
66
No,
years.
75.
75 years.
75 years of age, and kindly see the problems he's facing. Diabetes, hypertension, CAD, all kind of problems. And amputation of right foot. Amputation.
Money, my lords, I'm money.
Whatever
Whatever is for, my lords, it's up to the court, but he has, my lords, but he's the guarantor, the beneficiary,
No doubt about it.
70 lakhs, no money has been paid back. It's
So conviction, we are not going to touch at all. We are
Yes,
not
of
going to
course.
change the conviction at all.
Anyway, his review is not majorly on conviction, but is on
No,
the
not
my lords,
on-
consideration of the sentence imposed upon him.
We'll just,
I think he's already.
My lords, earlier this morning had mentioned it, my lords.
doesn't matter, we are allowing your petition, why you bothered? Sorry? Yes. Well, after having gone through the review petition, I wasn't there in the review, but I discussed with my brother. So I thought, we were thinking that considering the age, we can, okay?
But then my lords will increase the fine, which my learned friends have suggested.
Okay, we'll see. Delay condoned. Delay in filing the review petition is condoned. Order dated 15/10/2024 is recalled. Special petition is restored to its original number. Having considered the facts and circumstances of the case and in view of the ripe age of the petitioner being 75 years, we consider it appropriate to extend to him the same benefit that as in the decision of this court in Ahmed Masood versus State represented by the Inspector of Police, Criminal Appeal number 3410 of 2025, in which case, under similar circumstances, this court had reduced the sentence to that which has already been undergone, subject to payment of additional fine. Additional payment of additional fine and compensation.
That wouldn't be a fixed amount. It would depend upon case to
Subject to, that's why we are not mentioning, okay? We therefore, while confirming the conviction, we dispose of the leave granted per case, we disposed of the appeal, subject to the petitioner paying an additional amount of rupees.
70 lakhs, nothing has been recovered. I don't even know whether they paid that 50,000.
5 lakhs. Paying 5 lakhs. To whom?
It's to, as
Who
a
is
fine, as a
who is
fine.
the?
It's not a compensation, so.
That is to be paid to whom?
No.
It's not, it's a fine.
It will go to the, I mean.
It's a fine.
Not to any individual.
Yes, it won't go to any.
To the Prime Minister Relief Fund.
No.
Fund.
Army Battle Casualty Fund.
Fund, for sure. With these directions,
So why I'm doing it, I'll tell you.
Civil appeal stands disposed of.
So, Malaj, the fine will be going to them? Malaj,
Yes.
Only the fine.
Yeah.
But fine would be anyway going to
The amount otherwise,
I'm saying the
part of
fine
the
would
original
go to the
criminal
state.
order.
Malaj, that's my understanding. My fines won't be directly going to.
The additional amount that we have given.
Additional amount
fine,
will go to.
only that. Remaining will be as
Remaining will be,
judgment.
fine will go to the state.
Absolutely, as per the judgment.
Why I said army, I'll tell you. I did.
a journalist wrote to me that a blind man is in Agra and he's doing this. And he was interviewed by the journalist, and he told the journalist that he was an instructor in MDA, English literature. So the message was forwarded to the army chief by me. Within half an hour, that man was traced, and the army chief said he's now our liability, and his photo with 2 para commandos was sent to me. And now the army is looking after it.
No, I know that. But I've had a personal experience of like that, of a relative of mine who, because of circumstances, used to
This
work in the
15
army.
years old episode.
And was circumstances dispute with his family was reduced to very penurious circumstances. One information to the army, they took care of everyone. And today he's managed to whatever get back his budget.
That's a good one.
And army people are very, very strict. They don't accept help from anyone, but the only exception is the army. The only exception is the army. Otherwise,
Thank you. Sir.
obligements.
Greatly obliged, my lords.
On the next case.
Yes,
Yes, sir.
My lord, I'm a petitioner in person and I have filed the application to appear in person. Please allow me.
Please continue.
My lord, I have been
1 minute, no?
selected
We'll
in
just-
Madhya Pradesh Judicial Services on the post of the Civil Judge Class 2nd in 2017.
Book 490 of 2026 is allowed. Delay in filing the review petition is condoned. Maybe IAB exemption, applications. Application IA number 42284 is also allowed. Specially petition is the order dated so and so is recalled. Specially petition is taken on board. Please tell us.
My lord, I've been selected as a Civil Judge Class 2nd in Madhya Pradesh State in 2017. Thereafter, my mains examination and final selection, Honorable Madhya Pradesh High Court Chief Justice forwarded the list of the selected candidates to the Law and Legislative Department of Government of Madhya Pradesh. The Madhya Pradesh Law and Legislative Department ascertained 2 points. First one is the medical verification report, and second one is the character verification report. My medical verification report and character verification report are positive in nature, and state government, being an employer, recommended me to suitable for the government services. My counterparts has been given the appointment on the said post instead of me. Now the point is that
You are saying your contention was that the administrative committee doesn't have the power.
yes, actually, sir, my lord.
That's the reason why we thought we'll hear you.
My lord, thereafter, Law and Legislative Department, without evaluating the rules of 2018, which has been passed by the Madhya Pradesh state after the approval of Honorable Chief Justice of Madhya Pradesh, and he exceeded their jurisdiction and forwarded my case file to the Honorable Madhya Pradesh High Court Administrative Committee. Thereafter, Honorable Madhya Pradesh High Court Administrative Committee again reconsider my case and find that I am not suitable. But my lords, I want to place before these documents before you to see that the honorable committee has the 2 aspects. All matters, may I say, my lord, please?
Please read it. Yeah, tell us.
Administrative Committee, Madhya Pradesh Judicial Services, point number 2, all matters of transfer and posting, but not the initial appointment. Being the state government is the employer, and employer found me suitable for the government post. Why the Honorable Administrative Committee exceeded the jurisdiction and put their own views instead of the view of the state government, and recommended my case file to the Law and Legislative Department by stating that I am not suitable. But before this incident, Honorable Chief Justice, along with the selected candidates, have recommended me with the full court meeting, Honorable Judges, to the Law and Legislative Department that appoint the person. So, my lord, I want to place before some record that
Show us that 4th 10 2018 order. That is the administrative committee's decision.
yes, my lord.
There are two aspects of it. It has nothing to do about the integrity part of it. It's only the earlier instance of
Which is
where an FIR had been filed. But tell us the power part of it, about page 49. Especially petition there. Anyway, ask the other side. $49 million.
No, but tell me one thing, your matter was never placed before the full court.
No, sir.
It was only administrative committee.
Administrative committee or no opportunity have been given to me to represent.
We'll ask. This is the only thing we wanted to ask you. That the page 49 is the order.
My lord, we are for the state
You are the appointing authority.
My lords, we are seeking some time, my lords.
No, you are the appointing authority. State has recommended his candidature and
take time. We will list it. We'll sit again.
Okay.
Take time. Issue notice.
We'll keep it in Mayor.
Okay, we thought you were ready. We'll hear it.
Obliging.
Yes. So and so, learned counsel for the state.
R2 and R3, my lords.
R2 and R6 to file a counter affidavit. Issue notice karna. Counter affidavit. What time you want?
3 weeks.
Okay.
No, 2 weeks is good enough.
Just before the close.
Let it be before the vacation.
Okay.
You are very competent, sir. You can file it even within a week. And it's my state. I know how competent my state is. How efficient they are. No, please don't be happy. We are having a lot of problem with Jharkhand, Bihar, Madhya Pradesh. They don't file a reply at all.
File a counter. File a counter, we'll see.
Obliging.
To the main petition also.
Yes, sir.
Your Lordship, I am seeking 4 weeks' time to file my counter affidavit in this, Your Lordship. 53, Your Lord. Yes.
Yes. You want time?
Yes, sir.
Okay, just adjourn it. Next.
Great.
There's a letter. As per the letter, 55.
We have filed a reply, my lord.
Disputed question.
I filed the reply for
My
respondent.
lords, I beg to appear on behalf of the petitioner, my lords. The service report reflects that the office report reflects that 6 and 8 respondents have not been
Await
served.
completion of service. Next.
Grateful.
Grateful, my lords.
Seeing these online, if it
Well, it's,
maybe
not only because after your lordship's very specific notice, they've not filed a reply, but I want to take 30 seconds to show something interesting to your lordships. If my lord recollects, this is that matter where a person's insignia was misused. Now it transpires in 3 publications that there's a scam going on where the same address in England is used by these scammers, including this fellow's UK cert. I filed an additional document volume. I filed it, can be handed over if it's not easily available. Only 3 pages, Balas, 18 and 229 of that additional volume. IA number 138228. Sorry, IA number 138328. If my lord recollect, this is that one where UK cert.
Why haven't you filed a counter?
Your Lordships, I'm appearing for Nixie, Your Lordships. We were asked to come and enter appearance. Your Lordships, there was no direction to file reply, and more so, our entire reply, whatever we had submitted before the High Court, is already part of the record here, Your Lordships. Because that is what we had filed in the High Court, and it's already here. On that basis, Your Lordship, we can proceed. Everything is here. There's nothing that has been left out.
Then Lordship
They
will
have been
record that he
accepted.
doesn't want to file. Then please record that.
It doesn't matter. We'll take Monday.
We can argue on the record already available.
We'll hear you on
Law
Monday.
point is involved.
We'll hear you on Monday.
Your Lordship, on Monday?
Have it on Friday then, the following next Friday. Next Friday.
Tuesday.
Well, it's only 1 second if I may take, literally a second. Just if you see IA page 18.
No, it doesn't matter. Come on, Tuesday we'll do it.
Very well.
Tuesday. We thought the matter is one of those incomplete matters. That's why we didn't check it up. Tuesday we'll take it up and dispose it.
Very well, very well, very well. Obliged.
50. Yes.
Lordship, I request for a short passover.
At this stage, what passover? Just tell us.
End of the board, Lordship.
Okay, end of the board. Okay, then.
Item 60.
May it please.
Fresh matter, Mona?
Lord, this is that matter where students and college are in SLP, Lord, before your Lordship.
Both of them are here.
Yes, Lord. The college is actually a respondent. Lord, I am representing the college. Singad, my Lord. I have a solution today.
Supporting them.
Yes, of course, my Lord. Lord, I have a solution today because your Lordships had specifically said last time, please give me some solution for the
Only one short issue of.
Yes, the students, Lord, we are 150 students have filed this. Lord. What I am trying to say is that the whole thing came only because there was a teacher strike because of non-payment of teacher and non-teaching staff strike or non-payment of salary. Lord. Now out of 27 crores, 20 crores have been already given and only 7 crore remains. We are willing to deposit it by Tuesday and disburse all the salary. Lord, mine is a 20-year-old institution with all the infrastructure and about, there are so many teachers and non-teaching staff.
It's a different issue. We are not.
They are all working and the institution is alive.
That issue.
No, today the issue is to send out all these students to another institute, which is not possible because all of them have already joined in their NEET examination, chosen my college because I am one of the best there. Lord, I don't. Sorry, my lord?
You also filed an appeal.
We also filed a writ petition there, my lord.
Here.
No, not here. We are a respondent here.
As a respondent, you are asking.
But you wanted a solution. Now there is no strike. All staff are working. The hospital is functional. It's a 20-year-old hospital and the institute, my lord.
You weren't perhaps not there when we issued notice.
Yes.
Were you there?
No, I was not there on that day.
That's why we
I was not there.
we were actually not inclined to interfere.
This is a case where the students cannot be
We are not
dislocated
inclined to
also.
interfere. Mr. Sham Diwan also, we told him he had
No, I
agreed.
just- no.
Our intention was only to bail out
That
the students.
Present, I was only
and
saying
ensure-
that there is nothing that there is no problem today. The
and
students can
ensure
continue.
that, no.
No, sorry.
And ensure
Students
that
are continuing as
the last of our order
yes,
is required to take instructions only on one aspect of it.
yes.
Yes.
About the colleges to which the students are being transferred and whether those colleges are fully recognized or not. That's the
Yes,
only
so
point.
there is a development actually.
Yes.
What's that?
But after my learned friend completes, I'll just...
No, you tell us.
No,
Yeah.
you-
So I'll just mention 2, 3. So first I want to report a very, of course, the Dental Council and the Union of India will report. Will
They are
come back
here.
to you.
Who is appearing for?
Yeah, here.
Your Lordships, I appear for the Union of India. Your Lordships, the Maharashtra University has given us a list of colleges where the students are being transferred. We have confirmed them. All these universities are recognized.
Recognized.
No, but the number will be a problem.
All the students, all
No,
the
that's the
colleges.
recognition is not the issue. The issue
That's
is
not
that
the
their seat capacity
Yes.
is... See, okay, so can I just now explain so that my learned friends also hear? My anxiety as a student is, I don't want to lose a year. This is my primary anxiety.
That's the undertaking we'll take from them.
Yes. Now the problem is that the Dental Council, now I'm going to, first let me give you the positive development. The positive development is that yesterday or day before, though that order has not yet been uploaded, the High Court has directed, has accepted the report of the single person Justice Ketkar Committee. So that's a big positive step. And therefore, there will be a disbursement which is of some 80 odd crores of rupees. And therefore, what my learned friend mentioned with regard to the staff salaries and all that will be taken care of. But that's, that may be for the management. But for me, I'm most anxious that I continue to study over there. So now I'm just on that. Now the problem, this is one development. Now the second development is that there's a series of circulars out of which I'm just handing them over to the court, which has been issued now post facto by the Maharashtra University of Health Sciences. Just give it to them as well. Now, they have now started looking around and set up a committee to find out as to whether there is a capacity. So there are two issues today. First is that the Dental Council, in consultation with the central government, has to give that additional number of seats, because we don't want to be going into a college which doesn't have that sanction strength. That's one. The second point is that the request which has been made to the Dental Council is for academic year 2026-2027. Yes. And we are most concerned about 25-26 because my exams are being held are ordinarily held in June and the term ends in July. So my anxiety is I want to continue in this college for this academic year. Let the exam be conducted so I don't lose a year.
So who is for the academic council? There are two things that the students want. Our inquiry will be confined only to that. We are not here to bail out the college.
Correct.
The only thing is that only 2025-26 for them to take the examination. Two things are necessary to explain whether the colleges to which they are being transferred, do they have the capacity to accept them and so that they can take the examinations.
And we don't lose a year.
Secondly, number two, that whether they are recognized institutions or not. These are the two things which we want you to categorically tell us.
Yeah.
There is nothing more.
Yeah, from the perspective of not losing a year, that's the thing.
Who is for the dental? Who
Otherwise,
is going to answer that?
Yeah.
The government or the dental council? So far as the 25-26 are concerned. 25-26.
No.
So recognition, we'll put a tick mark. Capacity part of it. Who will explain capacity part of it?
Yeah, and central government. They have to.
You got instructions on that?
We have recommended, considered it, we have recommended
Ah.
to central government to take appropriate action in this regard.
You tell us about the capacity.
So the only question is for 25-26, because I find from the correspondence.
Very clear, Mr. Diwan.
Yes. This year.
One
and
thing,
next year.
There's very clear.
Yes.
There's only one thing in that.
No, wait. First of all, we'll finish the students. After that, we'll see.
Yes.
Yes.
Lordships, on the last occasion, it fell from my lords to
make an inquiry whether those students who are being transferred,
Colleges which are recognized.
those colleges are recognized.
That is clear now. They are all recognized.
That instruction I have got.
And second instructions which you have got is the colleges to which they are being transferred,
Lordship.
they will have a fixed capacity,
Lordship.
whether they can accommodate this additional capacity or not. You will have to take instructions.
That
on
the state can say, my lords, because
which state will say?
Because
They can't.
No, section 10.
So dental council will have to sanction.
I will see
Under section
Do one
dental
thing.
council.
Do one thing.
Oh, he's here, my lord.
Do one thing.
Under section 10A, it's the central government which have to increase
Yes,
the
that's what
You know that. You know that. You know.
That is a different matter, my lord.
What you do,
Capacity.
what you do is only one thing.
That is only on recommendation of central dental council.
What you do, you coordinate with the dental council. As central government, you are the additional solicitor general.
Lordship.
Bring them together, ensure that there is no difficulty for the students with respect to the capacity, pass necessary orders, and ensure that they take because you shift them out to colleges, then they will have problem in taking examinations, and then they will have problems about subsequent years, which should not happen. You take instructions, you put it up on Tuesday, you coordinate with all the three, the state, the central government, the state government, the medical council, as well as the dental council. You give us a categorical answer and also tell us that you have given instructions to those universities, your notification should indicate. So much so that there will not be any problem so far as the students are concerned.
But only one indulgence I
What do
see.
you want?
Because
Instead of Tuesday, can it be on Friday?
Coming Friday.
Coming Friday.
all right.
So that in the meantime, I will call a meeting.
Ensure
of them.
that everything is actually.
Yes,
Yes,
I will. I will.
I have a submission.
Okay.
How
One
can-
minute, we'll come to you.
Yeah.
So this thing is.
Yeah,
over
so
stuff.
but my pressing thing, because
After that, before we ask
the
for-
solicitor is here, they may just take it. That our, as they know, the academic year ends in July. So our exams usually are held in the month of June, July. So we want to, my desire is as a student.
It'll all be over, only by
correct.
Friday.
So that's
Friday.
right. Now, because the problem with
The students will not suffer, my lord.
yeah, correct. No, we don't want to lose a year, my lord.
We will ensure that. We will ensure
That's
that.
right. And the only other second point is that if this is a 5% increase or whatever that they are doing, because the request which has gone to the union government and the dental council from the correspondence that I have been able to locate based on the writ petitions filed in the High Court are for the academic year 6-7. We are concerned with 5-6. That's the point.
Very clear. It's very clear. I don't think anybody has any doubt.
No, 6-7, they may take their time, but 5-6 is what is emotional.
In
We may keep it on next Friday or whatever.
Friday.
May I make a submission?
1 minute. We'll just finish this and then we'll hear you. Because this is only about the students. In continuation of our order date 4/5/2026,
Lordship can.
we have heard, Mr. Who is for the council?
I want to make a submission before this, Lord. That's why it will
Tell us,
have a bearing on this.
Tell us.
Lord,
On this,
I am
it'll have.
on this itself. Lord, I am the college. The only problem the reason why the students are being shifted out has to be brought to the notice of this court, Lord, was that there were certain salaries which were not disbursed to the teaching and non-teaching. So there was a strike for internal assessment, which is the only reason for 26-27 was the order, which was impugned by the students, by the college, everybody. The de-affiliation was only for 26-27. What has happened is now, prematurely, the students started transferring the students for the batch of 25-26 also. That's why Mr. Diwan also keep on saying, all orders are about 26-27. But today, my lord, after your lordships issued notice, yesterday's order is, kindly treat this for 25-26 is the council, university's order, now it has come up. What I'm trying to say is, instead of allocating these students from the college which is the most reputed in Maharashtra and also most sought after, my lord, all meritorious students have opted for my college, which is operating for the last 20 years, my lord, in this field, has got not so many beds, 1 lakh patients visitors regularly, my lord. So therefore, what I'm saying is, instead of moving them out, give me the opportunity. It's only the salary. Strike has been called off. Teachers are coming. Non-teaching staff are coming. Why should the students suffer? Let them take the examination in my institute. I am conducting it for the past 20 years. Nobody will have an objection. Students are happy. Their hostel is there. They're all not 70% of my college students are not from the downtrodden background for which government is giving me subsidy. 240 crores for my 80 institutions have been not been paid over a period of time, which caused all this problem. Writ petition order, Ketkar committee says I have to be paid 90 crores. Not the order has come day before yesterday, which is to be uploaded. My 7 crore is what is to be paid. Why should they go elsewhere, my lord? No, why should they go elsewhere? No, matter of 7 crore, I am willing to deposit on Monday.
Diwan, then it can't be resolved. Then we'll hear all of you and then decide.
Monday I
No, let us.
No, but we'll have to hear her.
Yes, my lord.
No, but
The colleges.
see, can I just,
College is insisting that you should all be there with them.
no,
only.
can I just make a suggestion?
I'm sure the students.
The college doesn't want to leave you alone.
May I make a suggestion? Let us call it out on Friday.
Yes.
Let us call it out on Friday, because if we can file a solution, because they are in the main writ petitions are still pending in the High Court. We are waiting for that order to be uploaded. Frankly, the High Court may also be able
to put it up on Friday. We will not say anything for the present.
Yeah, for the present.
And the present, then we will hear the college and we will decide.
Yes.
Then students will be subject to what we are going to do.
We don't want to.
We don't know. The college says that college ultimately depends upon what we're going to say about that college. Suppose we don't agree, we'll have difficulty in restoring the student's position now.
No, my lord, student's position. See, the student's position is
You will have to choose, perhaps.
No, I don't want to choose, my lord. I don't want to choose. I can't afford to lose a year. Some of us are in second year, some of us are third year, fourth year.
That is why we are trying to bail you out.
I appreciate that.
We are trying to bail you out
Yes,
for
yes,
batting
yes.
for the students to
Yes.
ensure that the student gets
Yes.
it. But then the college doesn't want to leave you. So therefore we can't. So therefore college's money is involved.
My infrastructure.
No, it's not just the money involved. See what's happened is
All right, you make your choice.
No,
Mr. Diwan.
ordinarily.
You'll have to. That's the college in which you are appearing.
I am appearing for the 112 students. We all want to study in this college because we are taking great.
So therefore that's it. That's it. Then we will have to decide about the validity. So therefore what turns out eventually is that the students as well as the teacher are saying that we will continue, the school is saying that we will continue. Then the only question is about the validity of the transfers. So we will have to look into that.
Yes.
We are willing to study here.
So therefore, Mr. Diwan, behind you is the student who says, I don't want to shift. So leave it at that.
How in the middle of the year can you say? We can't lose a year, my lord. Ultimately, it's a question of career.
So then post it on Friday. Let us see some
Let
positive
us see if there's
development.
something. All right.
Some positive development
All right,
happens.
yes, maybe. What is surprising when I went through this correspondence, now your lordship is calling it out on Friday, is that after ordering the transfers, what was just mentioned, the new circulars now appoint a committee to find out whether you have the capacity to absorb students. How can you do it after transfer?
That's why I think something will come out on Friday.
Unbelievable.
My lord,
By
in this
Friday something will
circumstances,
come out.
do I need to take an instruction?
You take instruction.
Yeah, you take instruction.
Nevertheless, you take instruction.
Instruction?
Friday we will hear.
In what terms will I instruction?
Whether
If it comes, my lord, so that it will be easier for me, my lords.
you take instructions. Mr. Diwan, shall we direct the union to take instructions
Yes,
or
I
not?
think you may ask the union.
Not in the context of the opposition of the college and some of the students saying
Yes.
that we don't want to go.
No, but
That might become unnecessary.
Yeah, it may because it may be desirable for this academic year to continue in this college.
Generally, the court.
Anyway, you take instructions. You take instructions.
2 months, my lords. We have
Yes.
to give exam in June.
You take instructions.
40 students who don't want to shift there. We have already made it. 120 students.
You are appearing for whom?
What is their personal interest? I do not know. Then we are now trying to protect the students and the college.
Call for it.
You don't have to be so aggressive.
I never said solve by
Every hearing need not become acrimonious.
Next Friday.
Post before another bench.
No,
Let it go somewhere. You don't need to fight on small matters like this.
No, next
Small matters like this, you don't need to.
No, we need some help. That's why
But I don't know.
Friday.
I don't want every case to be acrimonious.
Come back for some help. For Friday. We are grateful.
My lord, if something is recorded, that will help me, my lord.
Let's see. Next.
This matter was heard last week, your lordships recall, that Tanmoy Nath and So my lords had heard this matter. This Tanmoy Nath and my lord, they had missed the bus in terms of the deadline.
yes.
So I was to get instructions on whether any, your lordships had already.
Yes, you're right.
Yes,
Once
just
more time.
one more week, just one more
Next
week.
week
We'll
we'll
give it
take it
a
up.
last. We'll give it a shot.
62.
Next Friday, my lords. Next.
Thank you.
Obliged.
Your mediation report has come. We've seen. You seem to have worked very hard. Thank you.
Your Lordship, before I begin with item 62, item number 62.1, 62.10 and 62.12, these three items, my lord, are wrongly tagged with this batch, my lord. These are pertaining to another issue of contractual assistant professors in which reply has not been filed. So these three matters.
This one, that there's the other batch which was tagged that day.
That is done, my lord. That is separate. This is for contractual art. That was contractual engineering colleges.
यार इसमें तो कुछ है नहीं.
Now remaining matters. Now in the remaining matters, my lord, only
already finished the argument last time, is it?
My lord, we are
almost all of them got relief by our judgment. Last week we.
This is a separate batch. It's a fresh.
What is the prayer here?
Yes, my lord. My lord, 3 years are important, not even dates. My lord, year 2008, all of us joined State of Gujarat as assistant professors ad hoc. The judgment which came yesterday was
the date of 3 years prior to what is the date?
2008.
9
May 2008.
May 2009.
No.
Before and after.
May 2008, my lord. They joined as assistant professors ad hoc.
Have been restricted prior to 3 years of filing of the petition.
Yes, my lord.
That's
the only issue. There is a core issue.
What's the High Court judgment say?
Now, my lord, single judge allows in my favor, my lord, page 160. My lord, I have also made a convenience compilation, my lord. Just 1-2 documents I'll show to your lordship. Ma'am, this is for you.
The division bench, what does it say? Just impugned order. Just read it.
Yes, please.
And outside AGB has submitted, the issue is clearly covered by the order of the.
My lord, page number 4, top, says, in the present group of caption writ petitions, the issue is, may I read this, my lord? Page number 4. The issue is only confined with regard to grant of arrears of salaries to the original writ petitioners who have approached this court belatedly, and the coordinate bench in the order dated 27/9/2022, while disposing of the writ petitions on identical issues, has confined the grant of such arrears from last 3 years from the date of filing of the writ petition. It is also noticed by us that the order of the learned single judge which has been assailed in the present group of appeals was also passed in the group of writ petitions, some of which have been decided by the coordinate bench by the aforesaid order dated 27/9/2022. Hence, the present appeal will also meet the same fate. The present appeal
which means that you will get in the same kind of a relief, right?
Now, my lord.
That's all. Nothing more.
Now, my lord, may I just read 2-3 documents, my lord. My lord, they have their own. My lord, the only I am being treated differently only on the ground of.
Because Mr. Balbir Singh Malazzi is otherwise locked up.
Ah, yes, it's all right.
My lord, just 2 documents I'll show, my lord, and I'll close.
We have gone actually out of the way to ensure that all of you are rehabilitated. If you convert that into again yet another service matter I want to raise before 3 months, everybody gets that. You can't stand on a different footing. Everybody gets that.
Lord, no, it's not like that. Lord, may I very humbly submit something? This is coming before this honorable court now for the first time. Lord, I have made a convenience compilation. I'll just show 2 documents and 1 judgment of this honorable bench.
No, what's the prayer that you are asking?
Lord,
you want it to be a
treated at par with Acharya Madhavi Bhavin and given from 2012. My lord, learned single judge, Honorable My Lord Justice Anjaria as a Honorable My Lord.
Come when? At what time have you come?
My lord, there was a difference of only 1 year. The Acharya Madhavi Bhavin batch, it is not a case of me being a fence sitter or waiting for 22 years like in Shivdas case, my lord. It is a case in Acharya Madhavi Bhavin, my lord, 2018, the relief was granted. Learned single judge as well as Honorable Division Bench concurrently held that I am identically situated than Madhavi Bhavin. Both of us joined in 2008. The only difference was that I filed in 2019, my lord, a year after.
So those who came late,
only 1 year late.
For all of them, I think you stood. For all of them, only one standard rule applies.
Lord, this is for the first time coming for the latecomers before this, your lordships, my lord. This is not a case where something has attained finality for our batch, my lord. May I very humbly say submit 2 things, my lord. They have a circular of 2014. I had shown that circular, I have attached that with SLP also, which says that if one group of employees are given some benefit, it should be extended to other group also. Year 2018, one relief was granted to identically situated Madhavi Bhavin.
we were under impression that the same relief will be extended by virtue of their circular to us also.
I think High Court is right. Huh?
And my lord, your lordship's judgment, my lord, just two documents may I read, my lord.
That's enough. I think don't stretch it too far. Thank
Lord,
you. Dismissed.
My lord, we are only.
Okay, fine.
My lord, can I just read one judgment of your lordship?
Not necessary.
SGT Girish, my lord, your lordship, my lord,
Stand on the
Sarate
same
has.
thing.
Oh, yeah, no, that's a different case.
Next.
My lord, then my lord make.
63.
My lord, may then kindly just distinguish these three cases, my lord. I think my learned.
Not
No, these three cases are separate, my lord. I am making a statement, my lord. These are against different impugn order. My lord, may kindly see the impugn order also. 62.1, 62.10 and 62.12.
This again, those lecturers are asking for regularization, right?
That is a separate issue. No, my lord, they are also seeking minimum of the pay scale. My lord, may I read the impugn order of 62?
Pay scale they have got.
No, 62.1, 62.10 and 62.12 have not got, my lord.
Then why
These are fresh cases, my lord. Because my lord, they lost their case in High Court and now they have come before.
They didn't get even the minimum pay scale.
No, my lord. I'm making a statement. My learned friend has not even filed reply, my lord.
File because you're getting so many matters tagged, my lords, and he's the one who is saying it's similar, then he's getting it
No, my lord.
It's become an industry.
No, my lord. This is the last batch which I have in the office as my lord.
No, what about minimum pay scale are they getting?
I'll have to see, my lords. He got 10 matters tagged together, then he's saying it is to be detagged. Now it is.
It is a registry which has tagged it. 62.10.
62 dismissed. 62.1 is the same footing.
62.1, no, my lord, it's different. Lata Ben, 62.10, that is Gayatri Parmar.
That's the minimum pay scale one?
These three are minimum pay.
Not given minimum pay scale. Which are those which?
Minimum pay scale are 62.1 Lata Ben, 62.10 Gayatri Parmar, and 62.12 Dhanusri. These three.
Just write down.
I'm noting that.
62.1, 62.10, and 62.12.
012. I'll see, my lords. I'll see.
Check. Those are the three matters.
These are
minimum pay scale is not given. We will ask them to give.
Please, my lords.
What about the remaining?
Covered.
Remaining, my lord,
All are the same.
Don't repeat that point now.
I'm not. Remaining all are covered by 62, which your lordships have indicated that they are going to dismiss it. But my lord,
The rest of it dismissed.
my lord, may I only just show one paragraph?
Again, no, don't go back.
Very well.
The others we verify and then tell us. We'll give them the minimum pay scale.
Very well.
Next.
Any date may be indicated in the other.
It will come next week. It will come.
Next week. Very
my
well.
lords.
Check it up and tell us.
Yes.
Very well. Deeply obliged, your lordship.
May it please, my lord. I am a charitable trust, my lord, running a school. The respondent is a contractor. There is a decree against me for 188, out of which 109 is the principal amount. Remaining is interest at the rate of 12%. My appeal is pending in the High Court.
Instructions.
So if it is giving BG, it has to be for the full amount with any nationalized bank. I have no problem.
Charitable, huh?
My lord,
full BG will give. Or 50%, at least pay some money. It can't be that you
my lord, the High Court has
pay
said
some money.
My lord, the High Court has said to deposit in court
How much is that?
130. That's the impugn order. Out of that, my lord,
High Court said that directed to deposit 1.3 crore.
1.3. Out of that, in fairness, my lord, I'll deposit.
50 lakhs you deposit.
I'll deposit 30 lakhs.
50 lakhs you
My lord,
deposit. The
I have to arrange
the bank guarantee.
I have to arrange the money, my lord. My appeal is still pending.
In modification, we will say 50% deposit. That should be enough, right?
50% deposit.
50% you deposit.
Remaining
we'll actually restore the. It's not the restoring the order.
No, my lord, it's not in. First appeal is pending. It's in my first appeal, my lord.
That is in your. That 50% was directed to be paid in which order?
41125.
There's no
411 granted stay subject to deposit.
So 41125 you are
Entirety.
granted in interim order, right?
Yes, my lord.
So you are not agreed by that. That's your.
No, that said completely.
130.
That's a complete amount.
Complete, okay.
Now it's 130, my lord.
Leave granted. Leave granted.
My lord, kindly just grant me 8 weeks to deposit. I have to arrange the money.
We will do it. Don't worry. Specialty petition is against an interim direction passed by the High Court in pending disposal of so-and-so in so-and-so dated. The High Court, by the order impugned before us, directed as under the court Karlena. Having heard the learned counsel for the petitioner and the respondent, we are of the opinion that the interests of justice will be subserved by directing the respondents to deposit 50% of the decretal amount.
My lord, impugned orders records 130, my lord.
No.
My honest,
of the
it'll be too much for me, my lord. I'm a charitable.
Again now, I mean, we have given it to.
I'm a charitable institution.
50%. The amount shall be deposited within a period of
8 weeks, my lord.
6
Please run me 8
weeks from today. With these directions, the special petition, the
Your Lordship,
stands disposed of.
would you also consider saying the remaining 50 you can extend the BG?
Okay, that's okay. Now the cash is coming to you.
No, there is no order for disbursal in my favor today.
We are not saying this.
I know.
He will deposit the money.
Yes, my lord.
Earlier, his prayer was for deposit the entirety.
Right.
He said the deposit the 50. Now the balance, asking him to give another bank guarantee is unnecessary because hard cash comes to you. Next.
I'll have to move another application for disbursal. There is no order.
No need for disbursal. You deposit.
Deposit in the court.
Yes.
Yes, and that will be auto renewed for the every year.
Yes. Okay, we will say that the amount. Which court will this be?
This will be before the High Court.
High Court, my lord, Karnataka High Court.
It's okay, court, the amount deposited.
I think there is already a rule, it automatically gets deposited, if I'm not mistaken, my lord.
They will take care. Next.
Obliged, my lord.
Lord, can I request your lordship to take this matter up on Monday? I'm being led by Mr. Ranjan Reddy, my lords. He's on his legs, my lords. I apologize, my lord. It's a fresh matter, my lord. And I just request your lordship to have it on Monday, my lord. He's on his legs for another call.
All right. Not Monday. Or quite date then.
Sure.
We'll see. There are quite a few days matters for Monday. We'll give some other date. Next.
Sometime next week, your lordship. Some urgency, my lord. Very well.
You are appearing in that as a caveator, yeah?
Yes.
We'll give some time.
Sure.
Pass on.
Me, please, your lordship.
Yes, Sanjay.
Lordship. Lordship. This is virtually misreading of a judgment, and interest on interest has been directed to be paid, my lord. Now, if your lordship will kindly turn to page 69, the award of the arbitrator, going behind the decree.
Amount which is determined,
Lordship,
is the sum.
Lordships.
It is on the sum that the interest is to be calculated.
Lordship.
Covered by a judgment.
Yes, my lord, it's covered by Morgan Securities, my lord. Now the court has gone on another judgment saying that that has been explained in Morgan Securities. Now, if you kindly see for a moment, my lord, page 69, my lord.
It's knowledge for us also. Every day.
Page 69 is the operative portion of the award. Now, if your lordship will see, award is very clear, my lords. Now, the respondents, my lord, summarized position about the claims are as follows. And finally, the respondents are to pay the amount of 48,25,142 to the claimant.
From a judgment, is it? You're reading from a judgment.
Award, my lord. From the
award.
Lordship, page 69. Kindly come to page 69, my lord, for a moment. Executing court cannot go beyond.
Not a question going beyond.
That is, my lord, the import is that only.
It's a calculation of it.
Your lordship's calculation here, if your lordship will see.
Has it? What is the sum for which execution is sought?
My lord, it is, my lord, the court, the arbitrator itself directed that the respondent are to pay the amount of 48,25,142 to the claimant Ketin Transport Private Limited within 60 days of the award.
48 lakhs is a sum total of refund security, interest,
which includes everything, my lord. It takes
interest
into
on delayed payment.
Interest also, yes.
So you are saying as it has already suffered interest on delayed
yes.
It can't further.
Your lordship.
Interest on delayed payment is actually a component. It is not interest in itself.
No, my lord. If your lordship will see here, increase in
so on 140, on 48, how much did the executing court?
No, the executing court is now saying that 89 lakhs.
89 lakhs?
Yes.
Lakhs is.
This is 48 lakh 25,142. And now the executing court says you deposit 44 lakhs. We had already deposited, my lords, immediately. And it says that you deposit 89 lakhs.
I'm very bad in arithmetic. So what do you say? So how, which judgment according to your prohibits?
Your lordship will see Morgan Securities, my lord. That is 2023 1 SCC 6.2 million. If your lordship will see,
Southeastern coalfields.
Word, Lordships.
and there is one connected matter also, my lord, that has not been cleared by the registry. So, by the common judgment.
Actually, it'll bear interest on the sum. This is the sum. So that
Lord, so far as interest pendentillite is concerned,
those are all gone. Pendentillite is again a component. That component all put together cumulatively will lead to the formation of 48 lakhs.
That's correct.
Subject to interest.
Yes, my lord,
48 is the
subject to
amount
interest means after post-award interest, my lord. Now that also has been fixed in the award itself, my lord, 18%.